There is no question of challenge to such arbitrator before such arbitrator. In such a case, that is a case which falls under section 12(5), section 14(1)(a) of the Act gets attracted in as much as the arbitrator becomes, as a matter of law, that is de jure, unable to perform his functions under section 5 to the court to decide on the termination of the mandate unless otherwise agreed by the parties. Thus, in all section 12(5) cases, there is no challenge procedure to be availed of. If an arbitrator continues as such, being de jure unable to perform his functions, as he falls within any of the categories mentioned in 12(5), read with the 7th schedule, a party may apply to the court, which will then decide on whether his mandate has terminated. Questions which may typically arise under section 14 may be as to whether such person falls within any of the categories mentioned in the 7th schedule, or whether there is a waiver as provided in the proviso to section 12(5) of the Act. As a matter of law, it is important to note that the proviso to section 12(5) must be contrasted with section 4 of the Act. Section 4 deals with cases of deemed waiver by conduct, whereas the proviso to section 12(5) deals with waiver by express agreement in writing between the parties only if made subsequent to the dispute having arisen between the parties. So that is the scheme of the Act. You are per se ineligible. And we don't have to go before you. You can be substituted under 14 with another arbitrator. Until unless a dispute arises if you are ineligible or not. And that is why in Perkins and TRF, it was said that if this person is per se ineligible. Where is the question or to act as an arbitrator? Where is the question of his nominating someone else? And that is why when the reference order in Tantia came, Tantia said that if merely because in court there was a panel sent to them if the person himself is per se ineligible, merely because he sends a panel of 5 and says pick up a panel of 4, pick up out of them 2 and I'll choose one of them. How does that counterbalance? And that is why Tantia said we disagree with the reasoning in court and were pleased to refer it to a Now, my lords, it's important for your lordships to see what was the reasoning in court that one paragraph on counterbalancing vis-a-vis the one paragraph. I'm not bothering your lordships with other findings in TRF, Perkins, which are in detail dealing with these issues. If you Please, my lords.
One is a clause 64 section. Clause methodology is a per se methodology. So therefore, it falls under what?
Yes.
So therefore, it falls under what?
No, my lords, then it 12(5) makes it ineligible.
12(5) has to be read.
Entry 1, my lords, of 7th schedule. Sorry, I didn't get it.
Yes.
I didn't get it. Entry 1. Entry 1. Arbitrator's relationship with the parties or counsel. The arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with the parties. Please, my lords.
All that is available.
Please, my lords.
All that is available.
In
fully satisfied.
In which chapter?
64 gets
in which chapter?
64 completely gets covered under 1 and completely gets covered under 1. That's the way we have to test. That's the way we have to test, right?
Yes. Manager will appoint. And general manager will appoint. And general manager is hit by the appointing authority. The appointing authority ineligible. Is himself ineligible. What Perkins and TRF say. That is what Perkins and TRF say. Cannot act as an arbitrator on his own. He cannot nominate another arbitrator. He cannot nominate another arbitrator. That is my respectful submission for your lordship's kind consideration. And so, to say that what you can't do directly, you can't do it indirectly either. And that is why, my lords, the principle which is also then emphasized is who has an overwhelming constitution of an arbitral tribunal. A person, apart from unilateral appointments, the other party not having a say, you're practically vesting it in a party who has been held to be ineligible himself, will now have an overwhelming or unilateral say in the nomination of another person. And that is why Perkins and TRF go on to say that indisputably lead to an impression that such a party will be the sole or the major appointing authority who will in turn have a bearing on the adjudicative process and charting out exclusively the course of the arbitration proceedings. That's the line and philosophy behind these two judgments. Now, my lords, would your lordships be kind enough to have Perkins, paragraph
Perkins,
16,
page
1273,
1273,
1273, volume
volume
3,
volume,
paragraph 16.
volume 3, paragraph 16 is on there.
Paragraph 16. Paragraph 16, if your lordships were to just.
Paragraph 16, if your lordships
Paragraph
were to just-
16.
Paragraph 16.
My lords have the paragraph.
Yeah.
But
My
in
lords
our
have the
view, that
But
has
in
to
our
be
view,
the logical
has to
deduction
be
from
the
TRF.
logical
Para
deduction from
50 of the
TRF.
decision shows that
Para
this court was
50 of the
concerned
decision
with the
shows
issue
that this
whether
court
the
was
managing
concerned with
director,
the
after
issue
becoming
whether the managing
ineligible
director,
by
after becoming
operation of law,
ineligible,
is
by
he
operation
still
of law,
eligible to nominate an
is he
arbitrator?
still eligible
The
to nominate an
ineligibility
arbitrator?
referred to therein
The
was as a
ineligibility
result of
referred to
operation
therein
of law,
was as a
in
result
that a
of
person
operation of
having an
law,
interest in
in
the
that a
dispute
person
or
having
in
an
the
interest
outcome
in the
of the
dispute
decision thereof
or in the
must
outcome
not
of the
only
decision
be
thereof
ineligible to act
must
as an
not only
arbitrator,
be ineligible
but
to
must
act as an
also
arbitrator,
not be
but
eligible to
must
appoint
also
anyone
not
else
be
as an
eligible to
arbitrator,
appoint
and
anyone
that such
else as an
person
arbitrator,
cannot and should
and that
not have
such
any
person
role in
cannot and
charting
should
out
not have
any
any
course
role in
to the
charting
dispute
out any
resolution
course
by
to the
having the
dispute
power to appoint
resolution
an
by
arbitrator.
having the
The
power to
next
appoint an
sentence in the
arbitrator.
paragraph
The
further
next
shows
sentence in the
that
paragraph
cases
further
where
shows
both the
that
parties could
cases where
nominate
both the
respective
nominate
arbitrators
respected
of their
respective
choice were found
arbitrators
to be
of their
completely a
choice were
different
found to be
situation. The
completely a
reason is
different
clear
situation.
that
The
whatever
reason is
advantage a
clear
party may
that whatever
derive by
advantage a
nominating an
party may
arbitrator of
derive
its
by
choice
nominating an
would get
arbitrator of its
counterbalanced by
choice
equal
would get
power with the
counterbalanced
other
by
party.
equal power
But in a
with
case
the
where
other
only
party.
one party
But
has
in
a
a
right
case
to
where
appoint
only
a sole
one party
arbitrator,
has
its
a right
choice
to
will
appoint a
always have
sole
an element of
arbitrator, its choice
exclusivity in
will always have an
determining
element
or
of
charting the
exclusivity
course
in
of
determining
dispute
or charting the
resolution.
course of
Naturally, the
dispute
person who has an
resolution.
interest in the
Naturally, the
outcome or
person
decision
who
of
has
the
an
dispute
interest in the
must
outcome or
not have
decision
the
of the
power to
dispute
appoint a sole
must not
arbitrator.
have the power
Now,
to
this
appoint a
was the
sole
reasoning, my
arbitrator.
lords, on
Now, this was the
counterbalancing,
reasoning, my
which
lords,
was
on
given
counterbalancing,
So one
which
party
was given
exclusively appoints an arbitrator,
party
this is
exclusively
counterbalanced
appoints
by
an
the fact that the
arbitrator,
other
this is
party
counterbalanced
exclusively
by the
appoints
fact that the
thereafter.
other
Yes.
party
So
exclusively appoints
this
thereafter.
was the
Yes.
this was the
Counterbalancing
yes. So this was the counterbalancing in Perkins that they talked about. Now please see how does score deal with
Now,
it.
please see how does score deal with it.
Yes.
Co-
Now please have
Yes.
core
Now, please have core
paragraph 36.
paragraph 36. Give me the page.
1306,
1306,
same volume,
same
Para-
volume,
36.
para 36.
1306.
1306.
With your lordship's permission. Para 36.
With your lordship's permission.
Clause
Para 36.
64,
Clause
subclause 3,
64,
subclause B.
subclause 3,
One of the Chief
subclause
Justice
B.
has.
One of
Clause
the Chief Justice
64,
has.
subclause 3, subclause
Clause
B of the
64,
GCC deals
subclause
with
3,
appointment of
subclause B of the
arbitrator,
GCC deals
where
with appointment of
applicability of
arbitrator,
section 12,
where
subclause 5 of the
applicability of
Act
section
has
12,
not
subclause
been
5 of
waived
the
off.
Act has
In
not
terms
been
of
waived
clause
off.
64
In
3B of
terms of clause
GCC, the arbitral
64
tribunal
3B
shall
of
consist of
GCC,
a
the
panel
arbitral tribunal
of
shall
three
consist
retired
of a
railway
panel
officers,
of
retired
three
not
retired
below the
railway
rank of
officers,
senior
retired
administrative
not
grade
below the rank
officers
of
as
senior
arbitrators.
administrative grade
For this
officers as
purpose, Railway will
arbitrators.
send a
For
panel
this
of at
purpose,
least four
Railway will
names of
send a
retired
panel of
railway
at least
officers
4
and
names
panel
of
to work
retired railway
as
officers and
arbitrators
panel to work
indicating their
as
retirement date to the
arbitrators
contractor
indicating their
within
retirement
60
date to
days
the
from the date when
contractor
a written
within
and valid
60 days
demand
from
for
the date when a
arbitration is
written
received
and
by the
valid
general
demand for
manager.
arbitration
The
is received by
contractor
the
will be
general
asked
manager.
to suggest
The
the general
contractor will
manager
be asked
at
to
least
suggest
two
the
names
general
out of
manager
the panel
at
for
least
appointment
2
of
names out
contractors
of the panel
nominees
for appointment of
within
contractors nominees
within 30 days from the date
within
of
30
dispatch
days
of the request
from
of
the
the
date
railways.
of
The
dispatch of the
general
request of
manager
the
shall
railways.
appoint at
The
least one
general
out of
manager
them
shall
as the
appoint at
contractor's
least one
nominee
out of them
and will
as the contractor's
simultaneously
nominee
appoint the
and
remaining
will
arbitrators from the
simultaneously
panel
appoint
or
the
from
remaining
outside the panel,
arbitrators from the
duly
panel or
indicating the
from outside
presiding
the panel,
officer
duly
from amongst
indicating
the
the
three
presiding
arbitrators.
officer
The
from amongst the three
exercise of appointing
arbitrators.
the arbitral
The
tribunal
exercise
shall
of
be
appointing the
completely within
arbitral
30
tribunal
days
shall
from the
be
receipt of
completely
names of
within 30
contractors'
days from the
nominees.
receipt of names of
Thus, the right
contractors'
of the
nominees.
general manager
Thus,
in
the right
formation
of the
of the
general
arbitral
manager
tribunal
in
is
formation of the arbitral
counterbalanced
tribunal is
by the respondent's
counterbalanced
power to choose
by the
any two
respondent's
from
power
out
to
of the
choose
four names,
any two
and the
from out
general
of the
manager
4
shall
names.
appoint at
And the
least
general
one
manager
out
shall
of them
appoint at least
as the
one
contractor's
out of
nominees.
them
My lords, with
as the
utmost
contractor's
respect,
nominees.
my
My lords, with
submission is
utmost respect,
this is where
my
the error
submission
lies.
is
This
this
is
is where
no
the error lies.
counterbalancing
This
in
is
the
no
eyes of law.
counterbalancing
This is
in
no
the eyes of law.
counterbalancing in terms
This
of
is
what
no
TRF and
counterbalancing
Perkins.
in terms of what TRF and Perkins.
Because the claimant or the respondent in that case
confined to the names
has
suggested
to
by the
be
railways.
confined to the name suggested by the
And
railways.
that's one.
Yes.
There is no
And
counterbalancing
that's one.
because the railways
And there
then
is no
appoint two.
counterbalancing because
Yes.
the railways then appoint
Yes.
two.
Panel also.
Yes. And
May
out
or
of
may not
these
miss
two
the
also,
panel
I give
also.
two,
And
you
out of
choose one
these
out
two
of them.
also, I give two, you
And
choose
my
one
lords,
out of them.
And you can't go beyond
And
the
my
panel
lords,
And you
chosen by
can't
the
go beyond the panel
railways.
chosen
this
by
was
the
no
railways.
counterbalancing,
this
and
was no
Core
counterbalancing.
never held
And
Perkins or
Core
disagreed with
never
Perkins
held
or
Perkins or
TRF
disagreed
ever.
with Perkins
It's not
or
as if
TRF
Core
ever.
disagreed with
It's
TRF
not
or
as if
Perkins.
Core disagreed
It held
with
it to
TRF
be
or
good law,
Perkins.
but thought it
It
was
held
right.
it to be good law,
Please
but
supply.
thought it was
Right.
You can
Please
choose
supply.
any color as long as it
You
is
can
black.
choose any color as long as it is black.
So there's no choice left. Yeah, that's
Also-
right.
So there's no
Also
choice
with
left.
a
Yeah, that's
very
right.
pertinent
Also
question
with
which
a
during the
very
course of argument
pertinent
Justice
question
Roy
which
had also
during the
put
course
on a
of
panel
argument
which is
Justice Roy had
given.
also put on a panel which
Ultimately,
is
a
given.
panel which is given.
Ultimately,
You
a
give me a
panel which
panel.
is
It
given.
can be a
You
broad-based
give me a
panel. It
panel.
can be
It
a
can be a
small panel. It
broad-based
could be
panel.
anything.
It
And
can
I'll
be
show
a
it
small
from
panel. It could
Heinz
be
case.
anything. And I'll
That
show it
panel
from
also will
Heinz
change from
case.
5 to
That panel also will
31.
change from
I'll
5
show to my
to
lords there.
31. I'll show to my lords
Ultimately,
there.
I may choose
Ultimately,
out of that panel
I may
someone
choose
I
out of
feel is
that
the most
panel someone
acceptable. That
I
still
feel
does
is the
not
most
mean
acceptable.
that the
That
person
still
is
does
my
not
choice.
mean that
A
the
question
person
that
is
your
my
lordships have
choice.
put.
A
You give
question
me
that
a
your
panel,
lordships
now
have
I'll
put.
choose what is
You
most
give me a
acceptable to
panel,
me
now
out
I'll
of those
choose what
30
is
names
most
or 40
acceptable to
names
me
or
out
10
of those
names.
30 names
But
or
that is
40
still
names or
not
10
my
names.
choice.
But that is
So
still
can
not
you
my
curb
choice.
my choice to
So
appoint
can
an
you
arbitrator?
curb my
I
choice
have to
to
choose,
appoint
I
an
will choose out
arbitrator?
of the lot
I
that
have
you've
to
given
choose,
me.
I will choose out of the
Because
lot
I have
that
no
you've
other
given me.
option to do that.
Because I have no other option to do that.
Is actually
Making a
truncated.
choice is actually
And
truncated.
also, it
And
hits at,
also, it
section
hits at,
18, which speaks about
section
equal
18,
treatment of both
Yes,
parties.
speaks
yes,
about
I'm
equal
very great.
treatment
I'm
of
very
both
great.
parties.
Yes,
I mean,
I'm
that's
very
the
great. I'm
core
very
of
great.
your argument. I mean, that's
Absolutely
the
on the
core of
panel
your
also.
argument.
So
Absolutely
a
on the
panel
panel also.
which is
So a panel which
unilaterally
is
curated
unilaterally curated
by one party alone,
by one
which
party
is
alone,
unilaterally curated by
which is
one party
unilaterally
alone without
curated by
any
one
say
party alone without
from the other
any say
party,
from the
with
other
respect,
party.
our submission
With
is
respect,
does not
our
give us the
submission
choice
does
as
not give us
mandated
the
by law
choice
or required
as
by due
mandated
process
by
of law.
law or
Taking a
required
cue
by
from
due
what
process.
fell from Brother
taking a
Narasimha,
cue from what fell from Brother Narasimha,
the panel that we give,
the panel that we
it
give,
said, pick any color,
he said,
but it has
pick
to be
any
black.
color, but it has to
Pick
be
any
black. color, it is deemed to be white. Any color, it is deemed to be white.
So,
Is
so,
that enough to say? And even
is
in that
that
judgment, I'll
enough to
come to
say?
my lords and
And
judge
even
show
in
where
that
5
judgment, I'll
became
come to my lords
31.
and judge show where 5
We don't
became
agree with that
31.
position also.
We don't agree with that position also.
Yeah, I have not in my mind. Term.
Mr. Call, you have provisions. Mr. Call, you have provisions. Impose an absolute ineligibility. Impose an absolute ineligibility. Read with section 7 schedule 12. Read with section 12. In cases where the arbitrator is not ineligible, in the meaning of the 7 schedule. Where do we actually source the prohibition in the act? In the act? On the one of the parties. Providing for a panel which is consistent with the 7 schedule.
If that person
Is
himself
is
incapable of
himself
ineligible or being
incapable of
appointed as an
ineligible
arbitrator,
or being
he
appointed as an
cannot
arbitrator,
also nominate or
he
provide a panel.
cannot also nominate or provide a panel.
How does he provide a panel?
How does he provide a panel?
Well, how does he provide a panel?
Well,
If the
how does he
GM
provide
is
a
to
panel?
provide a
If
panel,
the GM is to provide a
And the
panel,
other case are cases where the managing director could nominate an arbitrator.
right, because
right, because
Because you are the managing director, therefore you cannot nominate.
right, and similarly that managing director could not
and
give a
similarly
panel
that
either.
managing director could not
Because
give a
that
panel
panel
either.
is a panel curated
Because
by
that
him, my
panel is a
lords.
panel curated by him,
submissions-
my lords.
I mean,
The submissions,
on grounds of equity, what you say is, it makes sense, but where do you source
No,
this
so my
makes
lords,
sense?
my-
But where do you source-
My
No, so my
respectful
lords, my-
submission going by
my respectful submission
going
going
out
by
of purpose.
purpose.
That is
Please, my
going
lords.
out of person interpretation
Please,
on
my
the
lords.
basis of person.
Yes, yes.
Interpretation on the basis
Yes,
of
yes,
person.
yes, absolutely, absolutely. Your lordships are absolutely right.
Absolutely, your lordships are absolutely right.
Why not have a jurisprudential basis?
Why not have a
My lord, statute one is what your
My
lordship
lord,
said.
statute
All
one is what
parties
your
to be
lordship
treated
said,
equally.
all parties to be
If
treated
I
equally.
have to go,
If I have to go,
I have to go and be
if I
bound
have to
by
be go, I have to
a
go and be
panel
bound by
curated by the
a
other side
panel curated by the
and
other
choose
side
someone from that panel.
and choose someone from that panel.
Where is the equality between the
Where
two
is the
parties?
equality?
And my lord,
between
it
the two
will,
parties?
with great respect,
And my lord,
it leads
it
to
will-
serious
with great
erosion of
respect, it
confidence.
leads to serious
as far as the
erosion of
independence and
confidence
impartiality
as
is
far as
concerned.
the independence and impartiality is concerned.
Which may help your case. Reflect on it, which may help your case. Grounds. Could there be grounds on which a party may object to a panel suggested by the other side, though that panel is consistent with panel is consistent with, it does not breach the 7th schedule. It does not. In other words, what I'm trying to ask you is, in other words, what I'm trying to ask you is, provides you a panel, none of whom provides you a panel, none of whom in breach of the 7th schedule, is in breach of the 7th schedule. Legitimate objection on any other ground not falling within the 7th schedule. Any other ground not
May I
falling
with
within the
respect
7th
say
schedule.
My lords, may I
I
with respect
take
say
it that a panel provided is a panel
provided
completely
is a
eligible.
panel
Panel
completely eligible.
completely unaffected by
Panel
the rigors of
completely
7th
unaffected
schedule.
by the rigors
Any of the
of
entries
7th
therein.
schedule.
It's a
Any
panel
of
of
the entries therein.
impeccable
It's a
names
panel of
every which way.
impeccable names in every which way.
Your answer is this one under the arbitration
Yes.
law as it stands. Under the arbitration law as it stands. Each party has an unrestricted to nominate its own arbitrator. To nominate its own arbitrator. Untrammeled by the choice of the other party. Untrammeled by
Right.
the choice of the other party. You have to
Right.
test it on that ground.
Yes, yes,
You
my
have to
lord.
test it on that ground.
Yes, my
My
lords.
respectful submission for that is
My
that
respectful
if a
submission for that
person
is that
who
if
is
a
ineligible
person
to act as
who
an
is
arbitrator
ineligible to
and
act
is
as an
ineligible to
arbitrator
nominate an
and is
arbitrator
ineligible
is
to
also
nominate
ineligible
an
to give a
arbitrator
panel
is
of
also
arbitrators
ineligible to
who
give
are
a panel of
unaffected by
arbitrators
Schedule
who
7
are
entry 1 or
unaffected
any
by
other entry, but he
Schedule 7
cannot give
entry 1
that
or any
panel
other entry,
because
but
the
he cannot
reasoning
give
is the
that
same.
panel.
What
Because
you
the
can't
reasoning
do
is the
directly, you
same.
can't do
What you
indirectly
can't
either.
do directly, you
A
can't do
person may
indirectly
nominate
either.
someone, but that
A
nominee may
person
not
may
be
nominate
affected by
someone, but that
Schedule 7
nominee
at
may
all.
not be affected by
The
Schedule
managing
7
director
at
of
all.
railways could
The
appoint or
managing
nominate a
director of
person
railways could
who
appoint or nominate a person
Authority
who
to
not.
nominate.
Yes,
The
the
authority.
authority to
Yes.
nominate. If you
The authority to nominate. If you, sorry,
What happens is that the contractor, that is his case. He's concerned about his case. He's concerned about his case. Owner is concerned. But so far as the owner is concerned, NHAI, take for example railways, or take for example every day there will be a request. Every day there will be a request 10 to 15 or even 20 arbitrations. Every day 20 arbitrations. So there is a process by which they will have to continuously may become necessary to have some kind of a panel by which they will keep appointing arbitrators. If we give a declaration, if we of the nature that you are saying that you cannot have a panel at all, inter se in a contract between two parties, owner of a public sector and a private sector, and a panel is not permissible. If panel is
then
not
in each
permissible,
case, you will have to
then in each
individually
case, you will have to
identify
individually
an arbitrators and then
identify
appoint
an
the process of
arbitrators and then appoint it.
May I
the
ask-
situation will be very difficult.
May I answer, may I answer that, my lord? My lord,
May I
I'm
answer,
not for a
may I
minute
answer that, my lord?
suggesting.
My lord, I'm not for a minute
I'm
suggesting.
not for a minute suggesting
I'm
that cannot
I'm
be
not
a
for a
panel.
minute
I'm not
suggesting
suggesting
cannot
that.
be a panel.
I was
I'm
just
not
coming to it.
suggesting
Let me,
that.
I'll just
I was
formulate
just
and
coming to
complete
it.
this
Let me, I'll
submission.
just formulate and
My
complete
only
this submission.
submission is that the
My
panel
only
cannot
submission
be
is that the
curated and
panel cannot
unilaterally
be
given by one
curated
side.
and
For instance, I'll
unilaterally
give an
given
instance.
by one side. For instance, I'll give an
I
instance.
want to answer that
Yeah,
question.
correct. Yeah, I want
Why
you to answer that question.
the difficulty
Why
is arising because
the
owner is
difficulty
one.
is arising because
Contracts
owner
are
is one.
independent, contractors are
Contracts
independent.
are independent.
If it is a
Contractors are
society
independent.
of contractors,
If it is a society of
builders,
contractors, of
only
society
through the
of
builder
builders,
society that you
only
come
through the
to
builder society
railways
that
or
you
anyone,
come to
then you can have
railways or
a
anyone, then
common
you can
panel
have
between the
a
society of
common
builders
panel between
and
the society
railways
of
or
builders
NHAI.
and
But
railways
that is
or
not possible
NHAI.
because these
But that is
contracts
not
are
possible
happening
because these
standalone
contracts
with
are
various
Well
happening
taken.
Then in which
standalone
case,
with
how does
various
the
well
panel
taken.
get formed?
Well
then in which
taken,
case
well
how does
taken.
the
And I'll
panel
just,
get formed?
Well
just
taken,
answer
well
that.
taken, and I'll just
My lords,
just
just as
answer
an
that.
example,
My lords,
we now
just as an
have the
example,
India
we
International
now
Arbitration
have the
Center Act.
India International
We
Arbitration
have an
Center Act.
institution which is
We have an institution
it's an
which is
institution of national
it's
importance,
an institution of
presided
national
over by a
importance,
retired judge of the
presided
Supreme
over
Court of
by a
India.
retired judge of the
In this
Supreme Court
case,
of India.
What
In this
better
case,
examples than
what
neutral
better
institutional?
examples than
saying the
neutral
solution is
institutional?
Yes.
Saying the solution is
And
institutional
that's where the
Yes.
panel will lie.
And that's where
I
the panel
fully
will lie.
understand what your lordships are
I
saying.
fully
Different
understand what your
contractors
lordships are
going one
saying.
to the other. I
Different
understand that.
contractors
Your
going one
lordships
to
are
the other.
right.
I understand that.
My
Your
submission
lordships
is
are right.
twofold. One,
My
the
submission is
alternative
twofold.
mechanism
One,
for
the
appointment of
alternative mechanism
arbitrators
for
from a panel
appointment
is
of
available in the
arbitrators
form
from a
of these
panel
national
is
institutions.
available in the form of
These are
these national
acts
institutions.
passed by
These
Parliament
are
calling them
acts
institutes of
passed by
national
Parliament
importance,
calling them
institutions of national importance.
institutions of
Secondly, my
national importance.
objection is that the
Secondly, my
reasoning for a
objection is that
panel
the
that it cannot
reasoning
be
for a
curated
panel that it
by
cannot
an
be curated
ineligible
by
person is
an
the same what was
ineligible
there for
person
saying
is
that
the
he could not
same what
nominate
was
anyone.
there for saying
A
that he could
person who
not
cannot
nominate
nominate
anyone.
another
A
person
person who
because he is
cannot
ineligible,
nominate
the
another
nominated
person
person
because
may
he
be
is ineligible,
perfectly
that nominated person may be
eligible to
perfectly
act as an arbitrator, but he
eligible
can't
to
nominate
act
him.
as an arbitrator, but he can't
Similarly, he
nominate him.
cannot give me a panel of 30 or
Similarly, he
50 or
cannot
5
give me a
names.
panel of
Would it not be
30
very
or 50 or
extreme?
5
I mean,
names.
you're right. I mean, yours is an extension argument. You're right. I mean, But yours if is you an cannot act extension as an argument. arbitrator, Mr. But if you Railway, cannot you act can't as an nominate arbitrator, an Mr. arbitrator who will Railway, act you as an can't nominate arbitrator. an
And he may be
arbitrator who will
eligible
act as an
otherwise.
arbitrator.
And he may be eligible otherwise.
Very extreme. Because, would that not be very extreme? Because, would that not be very extreme? Because which Mr. Railways nominates, which Mr. Railways nominates, suffers from any ineligibility, suffers from any ineligibility, then it's a different thing. Because tell you why. Then it's a different thing. We are not really in the realm strictly. We are not really in the realm strictly. This is really an amalgam in many of these cases. This is really an amalgam in many of these cases of public and private
National
law.
Highways Authority,
Say
Railways,
National Highways Authority,
National Hydropower Corporation.
They are
National
dealing
Hydropower
with
Corporation.
contracts worth. They are dealing
Thousands
with
and thousands of
contracts
crores.
worth.
And they are
thousands and
purveying
thousands
in
of
public
crores.
money.
And
It's
they are
public
purveying in
expenditure and
public
public
money.
revenue.
It's
which is
public
being spent.
expenditure and public revenue
Now,
which is being spent.
Would they not have a vested
Now,
interest in
would
ensuring
they
that
not have a vested interest
we are not
in
only
ensuring that
concerned with
we are
the
not only concerned
independence
with
of the arbitrator we nominate,
independence of
but
the
we want
arbitrator
to
we
ensure that there is
nominate.
an
But we want to ensure that
overall
there is
an
an
independent
that
arbitral
there is
tribunal.
overall an independent
Therefore,
arbitral tribunal.
the overall tribunal, because
Therefore,
this
the overall
possibly may multi
tribunal, because
huge,
this
as we've seen the
possibly may
nature of the
multi
awards.
huge. We've seen the
Why
nature
should
of the
we
awards.
deny them completely
Why
the
should
right
we
to ensure
deny
that
them
the arbitral
completely the right
panel
to ensure
consists
that
of
the arbitral
independent
panel
people?
consists of
If they
independent
nominate,
people?
if they start
If
nominating
they nominate,
cronies,
if they start nominating
sorry, I
cronies,
use that expression, suppose they nominate a retired employee,
suppose they nominate a retired
certainly
employee,
there's a problem.
certainly there's a
Then you
problem.
point out something to indicate that this
Then you
panel
point out
does not
something to
consist
indicate
of
that this
independent
panel
names.
does not
But suppose
consist
they
of
give names
independent names. But suppose they
of
give
people which are
names
independent. Their only
of
intention
people
then
which
is
are
this.
independent. Their only
Do you
intention
have a
then is
problem with
this.
all the names we have
Do you have a
suggested?
problem with all the names we have
If
suggested?
you don't, what's the difficulty
you
about you
don't,
choosing one of
why,
them?
what's the
Malos, may I
difficulty
with
about you
respect
Then
choosing
your
one of them?
answer can
Malos,
only,
may I
only
with
be one
respect-
Then your
theoretically,
answer
that,
can
look, I
only
should have an
be one
untrammeled right to
theoretically
choose
that, look,
whoever
I
I
should have an
please in an
untrammeled right to
arbitration.
choose whoever I please in
May
an
I-
arbitration.
May I answer that? My lords,
May I
what
answer that?
is
My
sauce for
lords,
the goose is sauce sauce for the
What
gander
is sauce
is
for the
their
goose is sauce for
apprehension
the
that you
gander.
may just
Is
appoint
their
anyone
apprehension that
and
you may
not
just
from
appoint
here.
anyone.
We want to
and not
protect
from
our
here.
interest.
We
I
want
can
to
equally
protect
turn
our
around and
interest.
say
I can
that
equally
what
turn
you're
around and
curating
say
as a panel is
that what
something in
you're
which I
curating
have
as
a
a
crisis
panel
of
is something in
confidence. I
which
don't have
I have a
confidence
crisis
in
of
them.
confidence. I don't have
agree with you.
confidence in them.
If you have a crisis of confidence in the panel, certainly you have an objection, you have a valid objection, you have a valid objection. crisis
But
of
if you have
confidence in a
no
panel which they
crisis
are
of confidence in
curating,
a panel which
then
they
why
are
should you have an
curating?
objection to appointing
But
one
why
of
not?
them?
Why should
We also
but
see
why
that
not?
they
Why
should
should
not be,
any-
we also see that
Permitted
they
to
should
appoint
not be
outside
then
the panel.
permitted to
If
appoint
they
outside
create a
the
panel
panel.
of five,
If
suppose
they create a panel of
10,
five, suppose they create a
what
panel
sauce
of
for the
10.
goose is sauce for the gander?
What sauce for the
You
goose
must
is sauce
appoint
for the
one among
gander?
the 10.
You must
They
appoint
must
one
somehow
among the
appoint
10.
one among the 10.
They must
Committee
somehow
arbitrators will
appoint
then
one among
appoint
the
a
10.
third party
May I
arbitrator.
with respect say that
Third party arbitrator.
utmost humility will not be
Utmost
sauce for the
humility will
goose and
not
sauce for the
be
gander, because
sauce
that
for the
panel
goose
is
and
only
sauce for the
curated
gander,
by
because
them.
that panel is
Either-
only curated by
That's
them.
why I said
Either-
institutional
That's
arbitration
why I said
panels, where an
institutional
institution
arbitration
curates a
panels, where
panel.
an
And it's
institution
open to
curates
both
a
the
panel.
parties. Today,
And
we
it's
are
open to
talking
both the
about a
parties.
panel,
Today, we are
maybe the
talking
most
about
Except
a
that
insecure
panel,
institutional
maybe the
arbitration
most
still to kick
insecure
off.
panel.
Please,
Institutional
Manoj.
arbitration
It's
still
still
to
to
kick
kick
off.
off.
Please,
Manoj,
Manoj.
It's still to
we
kick off.
also
Manoj,
have, for
we
instance,
also have,
I'm giving
for
instances.
instance,
I'll give instances to your lordships.
I'll give instances to your lordships.
Manoj, we today have the Delhi Arbitration Center,
Manoj, we
the
today
Mumbai
have the Delhi
Arbitration
Arbitration
Center,
Center, the
all under
Mumbai
the
Arbitration
aegis of
Center,
working under various
all under the
high courts.
aegis of working under
Any
various
of these
high courts.
institutions.
Any
I'm
of these
not today going
institutions.
about questioning every
I'm not today
institution where
going
there is a
about
panel. I
questioning
just gave
every
an
institution
instance.
where there is
To
a
your
panel. I
lordships,
just
that
gave
there's
an
also an act.
instance.
After all,
To
we
your
have the
lordships, that there's
Hyderabad
also an
institution,
act.
the
After all,
Delhi
we have the Hyderabad
Arbitration
institution,
Center,
the Delhi
Bombay,
Arbitration
the
Center,
Mumbai
the
Arbitration Center.
Bombay, the
Any of
Mumbai
these
Arbitration
institutes working
Center.
under a
Any of
credible
these
institution
institutes working
and
under
can't
a
get more
credible
credible than the High
institution
Court
and
concerned.
can't
If
get more
any
credible
one of
than the
them
High
maintain
Court
a panel,
concerned. If any one
from
of
where
them
both the
maintain a panel,
parties go and
from
choose their
where both the
arbitrators,
parties go
then
and
the
choose their
whole
arbitrators,
perception of
then
not
the
only
whole
being neutral but
perception of
perceived to
not
be
only
neutral
being
comes in.
neutral but
Why
perceived to be
should
neutral
I
comes
be
in.
in any way
Why
fettered
should
by
I
the
be in
panel
any
you
way
create?
fettered
What is it
by
that
the
gives
panel
you the
you
superior
create?
right?
What is it that
Which
gives
I
you the
don't have to
superior
curate a
right?
panel just
Which
because
I
you are the
don't have
government
to
or a
curate a
PSU.
panel just because
That
you
you
are the
get a
government or
superior
a
right to
PSU.
curate a panel.
That you get a
And we
superior
should
right
not
to
go to an
curate a panel.
independent
And we
institution
should not go
which
to an
gives us a name
independent
of people
institution
which gives us a name
of
of
people
could select.
from which both of
What
us
is
could
it that
select.
just being the state
What is
gives
it
you
that
the
just being
superior
the
right?
state gives you the superior
That's not
right?
recognized, my lords, under the law.
That's not
There's no
recognized, my
superior
lords,
right
under the law.
vested in the state or
There's
any
no superior
institution.
right vested in the state or
At the
any
end of it,
institution.
at the end of it,
At
when
the
your
end of it,
challenges,
you
are extending the Perkins
challenges,
principle.
you are extending the
You are
Perkins
basically
principle.
founding it on the
Or
basis of
you are
18,
basically founding
equality.
it on the basis of
Equality, and my lords,
equality.
also, for instance,
Equality,
I
and
just
my
give
lords,
an
also,
instance.
for instance, I'll just
There
give
is
an
no
instance.
Not direct
There is
answer.
no gray area
Not
in the
a
act.
direct
Not
answer.
Not a
Gray
direct
area in the
answer.
act.
My
Not
learned
a
friend
print.
points
Not a
out
direct
something which I may
answer.
just
My
read
learned
out. It's
friend
not a
points out
direct
something
answer
which I
to
may
what your
just read
lordships
out. It's
asked
not
me.
a direct
For
answer to
instance,
what your
grounds of
lordships asked
challenge
me.
in section
For
12.
instance, grounds of challenge in section 12.
Conclude your submissions. We
Yes,
are about
my lords,
conclude your submissions. We are about
in all
my lords,
humility,
fast
my
we
lords,
have
I
done.
tried to
In all humility, my lords, I
cover it
tried
as fast
to-
as I
I
can.
tried to cover it
Yes,
as fast as I
We are not
can.
a lot of questioning
Yes,
for the
I
other side.
just,
We are not a lot
I
of
just have
questioning for
4
the
or
other
5.
side.
I'll just
my
run
lord,
through,
I
not
just have
read any
4
of
or
my
5. I
points.
just
The
run
point
through,
Just
not
point
read
out
any
in
of my
pointers
points.
4 or 5
Just
lines.
point
Summarize
out
what
in
you have said.
pointers 4 or 5
Can
lines.
I just point out one thing?
Yes,
In
can I
section
just
12,
point
my
out
lords,
one thing?
ultimately on
In section 12,
grounds
my
of
lords,
challenge what
ultimately
you
on
disclose
grounds
is
of
said
challenge what you
likely to give
disclose
rise to
is said
justifiable
likely
doubts
to
as to
give
his
rise to
independence or
justifiable
impartiality.
doubts as to his
Now, all
independence
that
or
I'm saying is
impartiality.
that the
Now,
moment
all
a
that I'm
panel
saying is
comes
that
from
the
an
moment
independent
a panel
institution,
comes from an
could be
independent
anything.
institution,
Those doubts
could
as
be
to
anything.
impartiality
Those
go.
doubts
But the
as to
moment a
impartiality
panel,
go. But
howsoever
the
impeccable
moment
the
a panel,
credentials,
howsoever
is
impeccable the
curated by
credentials,
one side
is curated
to
by
the
one
detriment
side,
of the others or to the
to
exclusion
the
of the
detriment
others,
of the others
there
or to
is
the
bound to
exclusion of
be
the
erosion
others.
of
There is
confidence
bound to
as
be
far as the
erosion of
independence,
confidence as
impartiality,
far
and
as the
fairness
independence,
of the tribunal
impartiality,
and the
and
process is
fairness
concerned.
of the tribunal
There
and the
is
process
bound
is
to be that,
concerned.
and given the
There is
relationship
bound to be that,
with
and
the
given the
state as it
relationship
occurs on a
with
day-to-day
the
basis in
state as it
contracts.
occurs on a
Because
day-to-day
your
basis
lordships
in
gave
contracts.
instances
Matlab,
or where
your
so
lordships
many
gave instances,
awards have gone
or where
against
so
the
many
state. There are any number
awards
of
have gone against the
instances.
state. There are
where
any number of
honest private
instances
parties have also
where
suffered
honest
at the
private
hand of the
parties have
state and
also suffered
PSUs.
at the
In
hands
such
of the state and
unreasonable
PSUs.
demands, claims
In
and
such
terminations being
unreasonable
made from
demands,
time to
claims
time.
and terminations
So
being
many
made
of
from
these
time to
companies have
time.
been brought to a
So many
standstill,
of these
bank
companies have
guarantees and
been brought
catched
to a
overnight.
standstill, bank guarantees and catched
Mr.
overnight.
Mr. Paul, there is
Actually, Mr.
some
Mr.
substance in
Paul,
what you are
there is
urging for the
some
another reason.
substance in what you are urging for the
Absent
another
this,
reason.
absent
Absent
a
this-
transparent procedure,
Absent a transparent procedure,
a lot of people, what they do, a lot of
a
contractors.
lot of people, what they do, a lot of
is to
contractors
completely
would
breach
do
the integrity
is
of the
to
process.
completely breach the
By having
integrity
the
of the
appointing
process.
authority appoint people
By
of their
having the
choice.
appointing authority appoint people of their
That happens
choice.
through the back door.
Absolutely.
That happens through the back door.
Absolutely.
So giving, that's
If
the
I-
reality, that's
if
the
I-
reality, giving,
Yeah, the Indian reality. This will
yeah,
not,
the Indian
this will
reality.
not,
This
find
will not,
in the
this will
Kluwer
not,
article or the Kluwer
find in the
laws
Kluwer
written in
article or the
Netherlands
Kluwer
or
Yes.
laws written in
Switzerland or
Netherlands
Geneva or
or
whatever.
Yes,
Switzerland or
absolutely.
Geneva, wherever.
This is the Indian
Absolutely.
reality.
Yes.
This is the Indian reality.
And that's why I
Yes.
said, my lords, there are
And that's why I
problems on
said, my
both
lords,
sides,
there are
and a party
problems
which can
on both
influence the
sides,
outcome
and a
of a
party which can
proceeding
influence the
can
outcome
also
of a
outcome the curation
proceeding
of a list.
can also outcome
So
the
if
curation
those
of
are
a
the
list.
parties we are looking
So
at,
if
then what
those
is
are the
the-
parties we are
what is
looking
it in
at, then
fairness
what is
that we
the-
should look at?
What is it in fairness that we should
Hopefully,
look
two
at?
honest parties who come to court,
Hopefully, two honest
what kind
parties
of a
who come
panel
to
would they
court,
look at? A
what kind
panel
of a panel would
under
they
the
look at?
aegis
A
of a
panel
national institute
under the aegis
or a
of a
respectable
national
institute like the
institute
National
or a
Arbitration
respectable
Center or the
institute
Delhi
like the
Arbitration
National
Center or the
Arbitration
Mumbai
Center or the Delhi
Arbitration Center.
Arbitration Center or the
What
Mumbai
could be a better
Arbitration Center?
solution than that?
What could be a better
Where
solution
you
than that?
completely erase any doubts that
completely
could be raised as
erase
to the
any doubts
impartiality
that could be raised
and
as to
fairness
the
of the
impartiality
tribunal, the
and
panel.
fairness of the tribunal.
Now, my lords,
the
quickly,
panel.
let me just run through.
Now, my lords, quickly,
Let me just run through 2 or 3
Let me
points on
just
the
run
judgments and then
through
I'm
2
done.
or 3 points on the judgments
Just
and then I'm
formulate
done.
them, so we take
Yes,
them down.
yes, my
Just
lords.
formulate them, so we take them
Yes,
down.
yes, my lords.
My lords, in line
lords,
with what I'm
in-
saying is
And in
also the
line with
judgment
what
of
I'm saying
HRD
is
versus
also the
Gale,
judgment of HRD
which
versus
is
Gale,
page
which is
1143,
page
volume
1143, volume 3,
para 18, your lordships may note,
para
effectively
18, your
saying
lordships may note,
that with the
effectively saying
246th Law
that with
Commission
the
report
246th Law
and the
Commission
amendments
report
which have been brought
and
about
the amendments which have
to
been
the
brought about
Arbitration Act, they did two things.
to the
They narrowed
Arbitration
the
Act, they
grounds
did two
of
things. They
challenge under
narrowed the
34
grounds of
and
challenge
they
under
introduced
34 and they
seventh
introduced
schedule and fifth schedule and
seventh
section 12
schedule and
was
fifth
amended
schedule
to the
and
Act.
section 12 was amended
The
to
Supreme
the
Court
Act.
emphasized
The
that
Supreme
in
Court
view of these
emphasized
narrow grounds
that in
now,
view of
we
these
must
narrow
be
grounds
even
now,
more careful in
we must
preserving
be even
independence,
more careful
impartiality
in
and
preserving
neutrality of
independence,
arbitrators,
impartiality and
which was
neutrality
said
of
in para
arbitrators,
18 of this
which was
judgment.
said in para 18.
That now you
of
have
this judgment.
further restricted the
That
grounds
now
of
you have
challenge.
further restricted the grounds of challenge.
Thus, even greater care
Thus,
as far as
even greater
neutrality and
care
impartiality
as
of the
far as
arbitrators is concerned.
neutrality and impartiality of the arbitrators is concerned.
My lords, as far as
My lords,
the
as
judgment
far
in
as the judgment in
Voestalpine is concerned,
Voestalpine is concerned, it
recognizes the principles
recognizes the
that
principles
it should be broad-based. In fact, that
that
5
it
was
should
made
be
31, the
broad-based. In
Supreme
fact,
Court
that
did not
5 was
interfere,
made
saying that
31, the
31
Supreme
is
Court
broad
did
enough.
not interfere,
It
saying
says
that
it should
31
be
is broad enough.
broadened.
It says
shouldn't
it should be
restricted to retired or
broadened. It
serving
shouldn't be
government employees.
restricted to
You
retired
must
or
have
serving
lawyers,
government
doctors,
employees.
chartered
You must have
accountants, all on
lawyers,
the panel.
doctors, chartered
But
accountants,
our
all on the panel.
objection to Voestalpine will
Our
still remain
objection
the
to
same on this
Voestalpine
one
will
limited
still
issue. Of course,
remain
it
the
should be
same on this
broad-based,
one
etc.
limited issue. Of course,
That
it
the
should be
panel
broad-based,
cannot be
etc.
unilaterally
That the
curated
panel
by one
cannot
side.
be unilaterally curated
That
by
part,
one
my
side.
lords,
To that extent,
That
even
part, my lords,
to that extent, even is also against it.
yes, my lords.
is
I'm
also
I'm
against
saying
it.
so, my lords. I have
yes,
to
my
bring it
lords.
to your
I'm
lordships'
saying
notice
so,
that
my
they
lords. I
said
have to bring it to
5
your
became
lordships' notice
30.
that they said
They said
Because
5
the
became
permit of
31.
they said
The
5
other issue,
became
my lord, which has
31.
not been
The
argued, which
other
was an
issue, my
issue
lord,
which
which has
arose in
not been
another
argued,
judgment of
which was an
the
issue which
Supreme
arose
Court,
in
which is
another
not the
judgment of
subject
the
matter
Supreme
here
Court, which is
today,
not the
but
subject
was
matter
touched upon
here
by core
today,
was that
but was
under
touched
entry
upon by
1,
core was
could
that under
retired
entry
employees
1, could retired
be
employees
part of the panel.
be part of the
That in
panel.
fact, my lords, the TK Vishwanathan
That in
committee
fact, my
report I
lords, the
wanted to
TK
point out to your
Vishwanathan committee
lordships. Your
report I
lordships may
wanted to
just
point
note,
out to your
para
lordships. Your lordships may just note.
3.88,
Para 3.88.
the report has gone to the Ministry of Law.
The report has
Para
gone to the Ministry of Law.
3.88,
Para
page
3.88,
10690.
page 10690.
Para 3.88, page
Para
10690,
3.88,
volume
page
4, TK
10690,
Vishwanathan committee
volume
report
4,
says
TK Vishwanathan committee
that
report
there
says
cannot be a
that there
volume
cannot be
4,
a
4A.
volume 4.
There cannot be a
4A.
panel
There
unilaterally given
cannot
from
be a
which I am
panel
required to pick
unilaterally
people.
given from which I am required to pick
It
people.
has to be jointly
It
either
has to be
prepared by the
jointly
two sides
either
or
prepared by the
institutional.
two sides
I'm
or
not bothering for
institutional.
paucity of time, my lords.
I'm
I'm
not
just making
bothering
your
for
lordships
paucity of time, my
take
lord. I'm just
notice of the
making your
concerned
lordships
para.
take notice of the concerned
That's the
para.
proposed amendment that is gone.
That's the proposed
Now, my lords, your
amendment that is
lordships have
gone.
also
Now, my lords, your lordships have also
Lombardy,
in
where your lordship said that
party.
it was covered by.
Where your lordship said that it was covered by
Ineligible. Result 12 something ineligible. Your lodges followed Perkins.
Your lodges
And then
followed
on the
Perkins.
pre-deposit part.
And
because
then
it
on the
talked about the
pre-deposit part,
percentage being
because it talked
pre-deposited
about
for
the
arbitration to
percentage
be
being
invoked.
pre-deposited
Your
for
lodges
arbitration to
invoked
be
the
invoked.
general principle
Your lodges
of
invoked the
legal
general
due process,
principle
unconscionable
of legal
contracts,
due
and something
process,
being
unconscionable
unconstitutional.
contracts, and something
Your
being
lodges held that
unconstitutional.
such a contract
Your
or a
lodges held that
clause
such a
which
contract
is
or a
unconscionable
clause which is
can be struck
unconscionable
down. As your
can be
lodges have
struck
held in
down.
many other judgments. So all
As
that
your
I'm
lodges
saying
have
is
held
that
in many
apart
other
from
judgments. So all
the
that I'm saying is
specific
that
that your
apart
lodges
from
are asking
the specific
for
that your
tracing
lodges are
the
asking
impartiality
for
to
tracing
the
the
clause in the
impartiality
Arbitration
to
Act, the
the
fact
clause
is
in the
wherever your lodges
Arbitration
have
Act.
found
The
a
fact
clause
is
to be
wherever your lodges
unconscionable,
have found a clause to be
constitutional, your
unconscionable.
lodges have dealt with it and
Constitutional,
struck
your
it down.
lodges
And
have
walk
dealt with
also,
it and struck it down.
walk
And
also, my
walk
lords, your
also,
lodges applied
walk
Perkins,
also, my lords, your
followed
lodges
Perkins
applied
and took
Perkins,
note of the
followed
Law
Perkins
Commission
and took
in that
note of
as
the
well, my
Law
lords.
Commission
I'm very
in that
grateful if
as
there's
well,
something
my
else,
lords.
my lord.
I'm very
assist in the
grateful if there's
rejoinder.
something else,
Very
my lord,
grateful.
that will assist in the
Now,
rejoinder. Very grateful.
thank you. Now,
Hello, do I have your lodge's liberty?
certainly,
Hello, do I have your lodge's liberty?
certainly,
Yes.
certainly, Mr. Kaur. Let's come back in 2 minutes. We'll just take a little. Come back in
break
2
for
minutes.
2
We'll just take a little break for 2 minutes and come back.
Please, Lord. Lord, I'll just address three of the points.
Lord, I'll
which
just
I wanted
address
to
three
give
of the
clarification
points
to.
Can you
which I
formulate
wanted to
it?
give
Lord,
clarification
the
to.
first point is, my Lord.
My Lord, the first point is,
Now
my
the
Lord,
short issue before your
now
lordship
the
is
short issue
whether
before
to
your lordship
sustain
is
an arbitration
whether to
clause
sustain an
as
arbitration
upheld in
clause
the court.
as
So
upheld in the
when
court.
this is coming,
So
let
when
us see the
this is
basics
coming,
of the
let
arbitration
us see
clause,
the
my Lord.
basics of the
Basics of an
arbitration
arbitration
clause.
clause,
my
it is
Lord.
also a
Basics
part
of
of a
an
contract.
arbitration clause, it is also
It
a part
also
of a
has all the
contract.
checks and balances.
It also
what
has all
normal
the checks
contracts
and
will have.
balances what normal contracts
The
will have.
better thing or better
The
positioned
better
situation
thing or
of an
better
arbitration
positioned
clause is
situation of an
because it is
arbitration
giving
clause
the
is because
responsibility
it is
to
giving the
both the parties to
responsibility
formulate a
to both the
quasi
parties
judicial
to
authority,
formulate a
which is going to be the
quasi-judicial
first step of
authority,
the
which
litigation
is going to be
process.
the first step
So
of the
all the
litigation
other
process.
clauses of a
So all the
contract
other
are
clauses of
mutual
a contract
obligations
are
and
mutual
responsibilities of the
obligations
parties.
and
So my
responsibilities
lords will
of the
never
parties.
go
So
into
my
the
lords will
extent
never
of using
go
public
into the
policy
extent of using
against
public
a
policy
contractual provision which
against
is a
a
mutual
contractual
obligation and
provision
commercial
which is a
things in
mutual
nature.
obligation and commercial
But this
things in
being
nature.
a clause
But this
where, my
being a
lord, it
clause
has a special
where, my
status
lord,
of
it has a
finalizing
special
or
status of
formulating
finalizing
the first
or
step of a
formulating
judicial
the
mechanism.
first step of a
This
judicial
is equal
mechanism.
to the powers of the High
This
Court
is
in Section
equal to the
11.
powers of the
So
High Court
such
in
a
Section
power
11. So
cannot
such
be
a power cannot be
diluted, altered, or
diluted,
tinkered using the
altered, or
party autonomy.
tinkered using
Party
the
autonomy has to stop
Party
in
autonomy
front of
has
the
to stop
public policy
in front
test.
of the
So
public
the
policy
public qualities
test.
test in
So the
Indian
public qualities
constitution
test in
cannot
Indian
even
constitution
imagine of having a
cannot even
1%
imagine of having
more
a
power to the other
1%
party to
more
formulate
power
a
to the other
quasi-judicial
party
authority.
to formulate a quasi-judicial authority.
100% in all means
100%
constitution
in all
ensures
means
and guarantees
Constitution ensures and
delivery of
guarantees
justice by a
delivery of justice by a
undisturbed or untilted
undisturbed or
institution.
untilted institution.
So a clause when it is
So a
crossing that
clause when
limit
it is crossing
of
that
tilting
limit
the equality,
of
even
tilting
by
the equality,
1% of it,
even
Lord,
by
it becomes
1%
unilateral.
of it, my lord, it
Not
becomes
even
unilateral.
1% of the
Not
power
even
given to one
1% of
party
the
more than the
power
other
given to one
will
party more than
make
the
that
other
clause unilateral.
will
Then
make that
in
clause
such a case,
unilateral.
public
Then
policy has
in
to
such
be
a case,
applied.
public policy has to be applied.
Point number 2 is, my lord,
Point number 2 is, my
with
lord,
regard to
with regard to
the appointment of
the appointment of
the tribunal, replacement of the arbitrators
the
by the
tribunal,
court.
replacement of the
I
arbitrators
beg to
by the court.
disagree with my seniors in
I
this,
beg
my
to
lord.
disagree with my seniors
Courts
in
do
this, my
not
lord.
have the power to appoint
Courts
the
do not have the
arbitrators
power
in case
to
of a
appoint the
replacement.
arbitrators in case of
Because,
a
my lord,
replacement.
an
Because,
arbitration
my lord,
clause has different
an
aspects
arbitration
of
clause
it.
has
It
different
has the language
aspects
of
of it.
arbitration, number
It
of
has the language of
arbitrators,
arbitration,
seat
number
of
of
arbitration,
arbitrators,
law
seat
applicable
of
to the arbitration,
arbitration,
all those
law
things.
applicable to the arbitration, all those
Particularly
things.
intention to arbitrate. That is the
Particularly
first point.
intention to arbitrate. That
When
is the
your
first
lordship
point.
is going to say that
When
a
your
particular
lordship is going to
appointing
say that a
procedure
particular
is
appointing
bad in law, which
procedure
is not, which
is
makes
bad in
that
law, which is
arbitration
not
clause
which makes that arbitration
unenforceable,
clause
then 11.3 comes.
unenforceable.
11.3
11.3
talks
comes.
about the situation
11.3
where
talks about
an
the
arbitration
situation
clause does
where
not have
an
a
arbitration
mechanism
clause does
to
not have a
appoint the
mechanism
arbitrator.
to
My lords, kindly
appoint
see
the arbitrator.
11.3,
My
my
lords,
lord.
kindly see 11.3, my lord.
May I read it, my lord?
May I read it, my lord?
The submission you are making,
My lords,
submission you are making, the point you are making.
Millards,
point I am making, my lord, there was
Point I
a
am making, my
submission
lord,
from
there was
my other
a
senior
submission
counsels
from other
saying that
senior
in
counsels
case the
saying that
arbitration
in
appointment
case
procedure
the
is
arbitration
held bad in
appointment
law by the
procedure
court,
is held bad
can
in
the
law by
court
the court.
appoint the, replace the
Can the court
arbitrators by
appoint the
themselves? By
replace
the
the
court.
arbitrators by themselves by the court?
So the court can appoint the arbitrators.
The court can appoint the arbitrators.
Therefore,
My
that
lord,
is the procedure is invalid, the court is
Millards,
the procedure is invalid, the court is not.
it's provided in the law, my lord.
It's provided
11.3
in the
says
law,
that.
my lord. 11.3 says that.
Yes.
A person of any nationality may be
A
attend the
person
the
of any
arbitrator.
nationality may be attend
Two
the
says
the
subject to
arbitrator.
subsection
Two
6,
says
the
subject to
parties are free
subsection
to agree
6.
on a
The
procedure for
parties are free
appointing the
to agree on a
arbitrator or
procedure for
arbitrators.
appointing the arbitrator or arbitrators.
Failing any agreement
Third,
referred to in
failing
subsection
any
2,
agreement referred
in
to
the
in
arbitration
subsection
where
2.
three
In the
arbitrators,
arbitration where three
each party shall
arbitrators.
appoint one
Each
arbitrator,
party shall
and the
appoint
two
one
appointed
arbitrator,
arbitrators shall
and the
appoint the
two
third
appointed
arbitrator,
arbitrators shall
who shall
appoint the
act
third
act as the
arbitrator,
presiding
who shall
arbiter.
act
So
as the
according to the
presiding
procedure
arbiter.
fails, so the procedure is held to be invalid. So the
Procedure held to be invalid. That
Procedure held to
particular
be
portion
invalid.
alone vanishes.
That particular
The
portion
rest of
alone
the
vanishes.
arbitration clause remains.
The rest of the
Applicable
arbitration
law will
clause
remain.
remains.
The
Applicable
number of
law will
arbitrators
remain.
will remain.
The number
Intention
of
to parties
arbitrators
will
will
remain.
remain.
Seat of
Intention to
arbitration will
parties will
remain.
remain. Seat
Only
of
missing
arbitration will
link
remain.
is
Only
appointment of the
missing
arbitrators.
link is
So at that
appointment of
point
the
of time,
arbitrators.
this
So at that
11.3
point
is
of
the
time,
appropriate
this
section
11.3 is
to
the
apply.
appropriate section to apply.
11.3 will come into play
11.3 will come
after
into
6,
play.
no? After 6, no?
My lord,
Under
My lord,
subsection 2 talks about 6.
Under
Yes,
subsection 2 talks
My lord,
about
Then the
6.
Yes,
point
Lord.
is something else.
Lord,
The-
Then the
anyway, you
point is
complete.
something else.
Make
Anyway,
your
you complete.
yes, ma'am.
Don't want
Make
to-
your submission.
Yes, ma'am.
My lord, 11.6 talks about
My lord,
all failures, my lord.
11.6 talks about all failures, my lord.
Ah, 6. 3 weeks.
So, my lord, my humble submission is, my lord, with
My lord,
regard to
my
the
humble submission is,
appointing
my lord, with
authority,
regard to the
for the court
appointing
is given
authority.
only in
For
11.6
the
and
court
section
is given
14.
only in 11.6
In
and
addition
section
to that,
14.
there is no provision
In
in law
addition to
which is
that, there is no
providing the
provision in law
appointing.
which is providing the appointing.
Lord, third one is regarding the
Lord, third one is regarding
tribunal,
the
sorry, this panel prepared by the
tribunal, sorry,
arbitrators.
this
my lord.
panel prepared by the arbitrators, my lord.
Lord, there are different types of
Lord,
panels.
there are different
prepared
types
by
of
PSUs, my lord.
panels prepared by
For
PSUs,
example, my
my
lord,
For example, my
my
lord,
opposite party,
uh,
IRCON,
my
has a
opposite
36
party,
people
IRCON,
panel,
has a
which
36
is all
people
engineers, which
panel,
was given to us,
which
which
is
we
all
rejected,
engineers,
then
which
we
was
came
given
here.
to us, which we rejected, then we
The
came here.
36 persons,
The
the difference
36
between
persons,
an arbitral
the
center
difference
or some
between
other
a
institution or a
arbitral
neutral
center or some
institution
other
is
institution or a neutral
the
institution
selection
is
of arbitral tribunal
the selection of
is
arbitral
transparent in
tribunal
nature.
is
If I have to
transparent in
apply to
nature.
IFICI
If
as
I
an
have to apply
arbitrator,
to
I got
IFICI
the
as an
empanelment.
arbitrator,
I
I
have to
got the
fulfill 10 years of
empanelment.
experience,
I have to
5
fulfill 10
arbitration
years of
cases I should
experience,
have done.
5
I
arbitration
should have an
cases I should have done.
exposure
I
into
should have an
arbitration
exposure
publications and
into
all. Fine, I am
arbitration
getting in it.
publications and all.
But I
Fine,
cannot get
I am
into
getting in
NHI.
it. But I cannot
It
get
is
into
closed.
NHI.
It is chosen for
It
some
is
people.
closed. It is chosen for some people.
So that also amounts to
So
a kind
that
of
also
limiting the
amounts
right
to
of the
a
other
kind
party.
of limiting the right of
If
the
it
other
is
party.
transparent to everybody, it's fine.
If it is transparent to
Or
everybody, it's
if
fine.
it is optional, it is fine.
Or if it is
You are
optional, it is
selecting
fine.
yourself and making it
You are
mandatory, how
selecting
it is
yourself
fine.
and making
It
it
cannot be fine.
mandatory, how it is fine.
Because you are
It cannot be
touching
fine.
my right, at least by
Because
one
you are
person,
touching my
which
rights,
is not
at least by one
permissible in law.
person, which is not permissible in
Because
law.
this panel also, they create
Because
one
this
big
panel
panel,
also,
larger
they
panel,
create one
and
big
then
panel,
they will
larger
suggest
panel,
a small
and
panel of
then
3
they
or
will
4, 5
suggest a
people.
small panel of
From
3 or
that,
4,
we have
5
to
people.
choose one among them.
From
So
that,
it
we
further
have to choose
reduces.
one among them.
So
So
that
it further
goes away.
reduces.
So in
So
case,
that
just as
goes
an
away.
example, in the case, just as an example, in the case of IRCON, can you select anyone from the 36, or they will give you 5 out of the
They
36?
will give 5 only, my lord, but High Court gave me a liberty to select from all. But our contention is, my lord, as long as the panel is selected at the discretion of some officers in the PSU or government, without a transparent procedure to select. Tomorrow you specify, these are the qualification. This is the month we open for empanelment. You select, fine. It doesn't happen. It happen as per the whatever it is. There are various ways. Or if they want to make a panel, as my lord said, NHAI may have 100 cases. They cannot go and select at that point of time. They have a panel. Then don't compel me to select from there. Let it be an optional panel. If I like, I select. Otherwise, I select from somebody else. That's all my.
Just one query.
Yes, ma'am.
Say railways, you have talked about railways. Now, in railways, there could be so many arbitrations requests.
Yes, ma'am.
Maybe every day there could be 50 or 100 arbitration
Yes,
requests.
ma'am.
Now, every time they have to look for somebody outside. If they don't have some structure in place, that from this will make choices.
Perfectly all right, my lord. My lord, we don't have any objection to having an arbitration panel by themselves for their use. For us also, it can be given as an option. These are the people, their profile is this. If you want, you can choose. But you don't make us also compelled to choose only from them. Let it be an optional panel, my lord.
No, optional panel is.
Because
when you
among
say-
the three, my
when you
lord,
say optional panel. How? We are just trying to understand your logic.
my lord, there are three arbitral.
No, just a minute.
Yes, my lord. Yes,
A panel is there. Say railways. Let's take railways. Panel is there,
yes, ma'am.
and you are saying that if they ask us to choose from there, it is all right, but they should not give those choice of 4 or 5. Is that
No,
what
no,
you are
my
saying?
lord. Even choosing, my lord, your my rights are reduced, my lord, because
Right.
it is
Then
not
how
a
are you
transparent
saying-
panel.
Then how are you saying that panel is all right?
He says.
My lord, panel. Because, my lord, the beauty of yes, my lord, I am not.
Railway can say that I select A out of my panel of 50,
Yes,
and the contractor says he is not of this 50, but he is my nominee.
yes, yes.
And between the two, they will have the.
Perfectly all right.
And if
That
the
is perfect.
contractor, according to you, wants to select one from the railway panel, that's fine. That's
Yes,
his
that's
choice.
fine, my lord.
Give him a choice according.
My lords, the beauty of arbitration is, my lord, if a party is selecting an engineer in an engineering contract, if contractor is selecting a judge or some legal person, that will be a very nice combination. No requirement for an expert witness. If there are two judges, there is a one engineer. So these all can happen when the liberty is given to us. When liberty is curtailed, all these go. Everybody sits, all three retired engineers. My lord, it's the last submission, my lord. Just one word, my lord. My lord, section 12, schedule 5 and 7, in my opinion, should be kept away while deciding this matter, my lord. This is a matter which is going to decide a system which is going to test the arbitration clause and its validity. My lord, that is a post-appointment system. The post-appointment system prescribes 19 items in the schedule 9 and 34 items in schedule 5. They are only an opportunity for the parties to know about their personal connections. So that is a different issue that should not be kept in mind while deciding this. Here, my lords are going to decide the validity of a clause or a system which will ensure neutral arbitration, my lord. Much obliged.
Thank you so much, Mr. Ravi Shankar. Mr. Rohan Talwar.
My lords, I'm going to address my lords firstly on a proposition which has not been discussed, which is the skewed incentive which arises in unilateral appointment procedures. My lords, on two stakeholders, one is the appointing authority,
So you're saying skewed incentive.
my lords, in cases where there are unilaterally appointed panels or unilaterally proposed panels. Lords, firstly, qua the appointing authority, anyone who is going to be rendering a verdict in their favor, there is a perverse incentive in economics which is called to reappoint that person in the panel. And my lords, it's a known thing that panels are reviewed periodically and thereafter curated. My lords, the second skewed incentive is of the arbitrator in this case, who, my lords, has an incentive to remain on this panel. So, my lords, what would happen is that
What is the first skewed incentive?
my lords, of the appointing authority, that if I'm an arbitrator and I give a judgment in favor, let's say, of the appointing
Be
authority,
reappointed.
I'll be reappointed. And
And there is no provision in the act which bars reappointment in more than one arbitration.
absolutely, my lords. My lords, there may be
Sorry?
cooling,
3 times.
Beyond 3.
and
Schedule 5.
my lords here, so
Schedule 5 item.
Schedule 5 is it? 5 or
Schedule 5.
Previous services. Item 20.
20. Yes, ma'am, 20.
Data has within the past 3 years served as
22.
been appointed as an arbitrator on 2 or more occasions by one of the parties or an affiliate of one of the parties.
my lords, however, this is on the point of impartiality at the stage where I'm questioning the appointment. I'm saying that in a year,
So in 3 years, you can't accept more than 2 arbitrations from one party.
my lords, however, if I'm to be
Therefore, it's clear in a case where you come across a situation where a person in the panel has already been appointed twice, you would say that you can't appoint him at all.
my lords, firstly, these aren't
That's
disclosed.
different from what's being argued.
But what one of you was saying after.
Repeated.
My lords, I will only pick a
Good point.
person even after the scope of 3 years who has decided in my favor, and within those 3 years, I can repeatedly appoint up to twice for someone who's decided in my favor. This is qua the appointing authority, let's call them railways. For the arbitrator also, my lords, the perverse incentive is to remain on this panel. And my lords, I may be on several panels. I may duplicate my appointment, and therefore this perverse incentive, in fact, is recognized in a judgment, my lords. It's by the name of Hooters of America versus Phillips. It's at page 3585 of volume 3, my lords.
Hooters was actually referred to in that judgment which was cited by Mr.
My
Banerjee.
lords, Mr. Banerjee also referred to it. There's just a sentence there which I want to refer to, my lords. So here also there was a panel.
So what they have held, they said that such person is ineligible to be appointed.
My lords. And there's a very interesting sentence, my lords, just following from what my lords said.
Read.
My lords, I'm at page 3589, relevant. The appointment procedure is the employee and Hooters each select an arbitrator, and two arbitrators in turn select a third, similar to core, similar to my case as well. My lords, the bottom of that paragraph, fourth line. Further, nothing in the rules restricts Hooters from punishing arbitrators who rule against the company by removing them from the list. Given the unrestricted control that one party, Hooters, has over the panel, the selection of an impartial decision maker would be a surprising result. My lords, this is one incentive I wanted to.
Interesting. So within a period of 3 years also, you appoint an arbitrator on a second occasion.
Absolutely.
And once, even after the period of 3 years, the bar of 3 years has expired, you'll have an eye on who held in your favor in
I
a
have
previous
data, my
arbitration.
lords.
That's your point.
3
That's
years
got
may be
your
a
point.
cooling off period, but after that, as my lords are saying, I'm aware who is decided in my favor.
So therefore, in the new proposed amendment, exactly this is what it is. The proposed amendment says that we will now have, instead of a prohibition, a cooling off period.
Apologies, my lord, I couldn't.
There's a cooling off period suggested by
My
the new
lords.
panel.
And my lord, the second point I want to raise is regarding the legislative infraction. What is exactly prohibited under this act? My lords, I want to read a sentence at the cost of repetition in TRF and one sentence in Perkins. If my lords may have page 1033 of TRF.
What do you want? Was the submission?
My lords, the submission is that there is a implicit legislative bar arising out of the fact that an individual who has an interest in the outcome of a dispute cannot be made the appointing authority.
That Mr. Paul argued.
My lords, just a sentence to show where is this coming from legislatively. What is the statutory bar here, which these two decisions in my respectful submissions have addressed already. My lords, at para 57, 1032 bottom, in such a context, the fulcrum of the controversy would be, can an ineligible arbitrator like the MD nominate an arbitrator who may be otherwise eligible and a respectable person? As stated earlier, we are neither concerned with objectivity nor individual respectability. We are only concerned with the authority or the power of the managing director. By our analysis, we are obligated to arrive at the conclusion that once the arbitrator has become ineligible by operation of law, he cannot nominate another as an arbitrator. And I'll end at the next sentence. The arbitrator becomes ineligible as per prescription contained in 12.5. Now, my lords, this is interpreted in Perkins and without apologies. Lords, this next sentence from Perkins is at 1274, my lords. I'm reading paragraph 16, where they interpret what is this Well, I'll just read that sentence. The ineligibility referred to therein was as a result of operation of law, in that a person having an interest in the dispute or in the outcome of a decision thereof must not only be ineligible to act as an arbitrator, but must also be eligible to appoint anyone else as an arbitrator. My lords, at the foot of this paragraph, that has to be taken as the essence of the amendments brought by the Arbitration and Conciliation Amendment Act 2015. Independence, my lord said, is a complete virtue. It can't be negated at margins. So, my lords, if independence has to be seen as an absolute virtue, this amendment introduced independence and impartiality. What my lords have said in Perkins is that the essence of this amendment is that an interested party cannot adjudicate. If an interested party cannot adjudicate because they have an interest in the outcome, they cannot nominate. Now, whether I nominate 1, 2, or 100 is immaterial.
Thank you. Thank you, Mr.
My lords, obliged, my lords.
Now,
It
Mr.
is-
Anirudh Krishnan.
Keep it extremely brief, my lords. My lords, I locate impermissibility under three heads. First, Section 18 of the Arbitration and Conciliation Act. Second, Section 23 of the Contract Act. And third, where there's a state party involved under Article 14. Insofar as Section 18 is concerned, my lords, my note contains various references, a lot of which my learned senior Mr. Banerjee has already referred to. But in substance, my lords, what Section 18 proscribes is the inequality in the process, including the appointment process. What it requires is absolute equality. And if absolute equality is not guaranteed at the stage of appointment, absolute equality is impossible during the process. Now, this, my lords, this equality is completely independent of independence and impartiality. Independence and impartiality is a separate paradigm covered by Section 12(5) and the two schedules. Equality, and when I refer to equality, I'm referring to the lack of mutuality in the appointment process. Any unfair advantage that any party has at the stage of appointment will result in a violation of Section 18. Let me give an example. There could be so many scenarios where the panel is perfectly eligible, but the party nominating the panel may fill the panel with arbitrators who have already decided a similar issue in their favor in the past. So, in such a scenario, my lords, there is no fifth schedule or seventh schedule violation, but there will still be a violation of right under Section 18, because why should one party have the right to fill the panel with people of their choice?
In fact, you're right. I asked a question in the morning. Are there any apprehensions or objections independent of the seventh schedule? And this is what you are saying, that you appoint.
And I can give a real life example. We did multiple arbitrations in relation to metro rail construction. There was one exclusion clause which was the subject matter of litigation in most of these arbitrations. Now, the first set, we had a completely independent panel. The second set of panels that were given to us comprised of only those who had interpreted that clause in favor of the Metro Rail Corporation. Now, today, if the Metro Rail Corporation has this unilateral power, it's independent of fifth schedule, independent of seventh schedule, but is it not a violation of equality under Section 18, I ask myself. This is the first point. Second, my lords, to answer a query that fell from your lordships is that this Section 18 is located under Chapter 5, which deals with conduct of the arbitration.
But does that not go to the panel as opposed to, the power?
Sorry, my lords?
Does your argument not therefore impeach the panel as opposed to the power to?
My lords, the panel is perfectly eligible because there is no question of subject matter. There is no entry relating to subject matter bias in fifth schedule and seventh schedule.
Well, really speaking, as no, it doesn't encroach, does not breach any provision of the statute.
It doesn't breach any provision of the statute, but the panel comprises of only those arbitrators who have decided the very same issue in favor of the party appointing the panel. That's the reason why, my lords, even though party autonomy is important, party autonomy has to be balanced with,
Against each of-
sorry, my lords.
As against each of the arbitrator who had decided similar cases against them.
They have only decided one such case, but that's enough. They have not decided more than two, so therefore fifth schedule will not come in. So today there is no grievance against the individual arbitrators, but it is that party that has filled the panel with persons who have already decided the issue in the past. A party should not be permitted to weaponize the appointment process.
Party autonomy cannot be for one of the party, but party autonomy has to be mutual for both the parties.
And I bow down, my lords, and party autonomy has its limits. If there is a mandatory provision of law, such as Section 18, party autonomy would give in to such a mandatory provision, because having a blemishless process is an equally, if not more important consideration. Today, your lordships has laid down the law in relation to minimum judicial interference. Why? Because it presumes that the regime is blemishless today, because of the fifth schedule, because of the seventh schedule.
Ramesh, in TRF, they mentioned that we are not concerned about respectively, right?
I bow down.
So, persons who have decided on a particular aspect in favor of the organization, may be more respectable.
I go back to what my learned friend argued on the incentives for appointment. Yes, my lords. Then, my lords, before I conclude, my lords, there is one passage, I don't think I'll have the time, but I'll only provide the reference to the drafting history. Some portions of the drafting history my learned senior read out, but at page 9823, volume 4, tab 135.
But you know, your point that, look, suppose they constitute a panel, and that panel only consists of people who have arbitrated in the past and say decided that issue, construction of a specific notice provision for termination favorably to that particular employer. Can you not raise a ground of challenge under 12A?
My lords, because it's not any of the grounds contained under Schedule 5 or 7.
No, but 12A doesn't confine you to only the 5th or the 7th schedule. The 7th schedule. 12 says, such as the existence, either direct or indirect, of any past or present relationship with, or interest in any of the parties, or in relation to the subject matter in the disputes, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence or impartiality. So suppose a railways or any PSU appoints an arbitrator who has decided that very issue. All the arbitrators in the panel are people who have decided in their favor.
My lords, may I, there are two aspects.
This not be a ground of
First,
challenge.
I will never know as a contractor, because what needs to be disclosed would only be what is set out in the 5th schedule. So if this is not covered on the 5th schedule. So I will never know whether they have decided in the past or not. Point number one. Point number two, let us assume that they have decided the same issue, not in relation to the same Metro Rail Corporation, but in relation to another public sector undertaking. Your lordship sees exclusion clauses in so many cases, so many government contracts.
You have decided the same interpretation.
Same interpretation. So why should one party have the benefit of
There
picking?
is an asymmetry of information according to you, because the contractor will not know everything about that arbitrator
I bow down, my
or
lord.
each of the arbitrators.
And my lords,
Identifying the background, you'll have to engage a detective agency to find out the background of the arbitrators.
my learned senior also mentions that HRD Gale.
Same was rejected.
Where?
HRD versus Gale, the arbitrator had given a similar award earlier.
That was rejected.
Yes. So, my lord, the problem here is the process and not the individual, my lord,
Who's
arbitrator.
concerned?
That's the real problem.
My lords, then, my lords, on the issue of whether, even though it is located in Chapter 5, whether Section 18 will apply to the arbitral appointments, my lords, there is one reference I would like to provide your lordships. at page 9823, volume 4, tab 135, which is part of the drafting history of the UNCITRAL model law. My learned senior read out certain portions. This portion also deals with it and specifically says that it will apply to the agreements between parties in relation to the procedure for the arbitration. And even when your lordship sees the scheme, even though it says conduct of arbitration, 18, 19, and 20 are prior to the notice of arbitration. 19.2 gives parties to agree upon the liberty in relation to the procedure. 21 gives parties a liberty to agree upon the place of arbitration. Therefore, when you look at the scheme, even though Chapter 5 deals with conduct, it begins with the agreement between parties on various aspects before going into 21, which is the commencement of the arbitration, and thereafter the procedures like pleadings, etc. in the arbitration. Therefore, my lord, the reading of the scheme, along with the drafting history in my respectful submission, would in my respectful submission make it clear that section 18 applies to the appointment process as well. This passage, my lords, is very, very clear. The passage that I just mentioned, I've referred to it in my note, my lords. I don't want to read it out because of the paucity of time. Finally, my lord, just one, before, if your lordships is to accept this contention that section 18 applies, there are various issues that will arise. What happens to arbitrations that have been concluded? What happens to arbitrations where the challenge is pending? Because section 18 was unamended, it will apply even in the pre-2015 era. Therefore, your lordships may consider using the power under Article 142 to restrict the applicability in a post-2015 scenario where a challenge has been raised and is pending before a court today. Because if it is going to apply across the board, it will. Second consequence, what happens if the offending portion alone is severed? Can the doctrine of severability and blue pencil rule be adopted, and can the court then go ahead and appoint an independent arbitrator? In this regard, my lords, if one party has provided consent on the basis that it has a right to unilaterally appoint or appoint a panel, that goes to the root of the consent to arbitrate. Therefore, in my respectful submission, the doctrine of severability and blue pencil rule cannot be read in because it vitiates consent in the first place. So if your lordship is to accept the section 18 argument, the arbitration clause itself goes, point number 2. Point number 3, who can raise it? Can today the party that has nominated the panel and thereafter lost in the arbitration go and challenge it saying section 18 has been violated? In my respectful submission, your lord, that the answer would be no, because in such a scenario, the right under section 18 itself would not kick in. Section 18 is a right that accrues for the benefit of the party that is discriminated against. Deeply obliged, my lord. There are a lot of foreign judgments and articles that I've referred to in my note. I don't want to go into all of them. Deeply obliged.
Lord, I will take 4 minutes exactly since, Lord, I appear for Shaparji Palanji, Lord, which is a contractor. We had filed an intervention, Lord, and mentioned yesterday. Lord, I've mailed my note to the court master, and very briefly, I've formulated my points over the lunchtime. I just get copies. We are carrying the hard copies also, Lord. Lord, very quickly, my points.
The submission.
Lord, my submission is obviously to say that 4 points, Lord, I'm making. Section 7, which talks about arbitration agreement, does not include an agreement on who will appoint. It's only limited to intent to arbitrate. And I'll read section 7. Means an agreement by the parties to submit to arbitration. So once that test is satisfied, the second conditions which parties often put, that unless I appoint, only then I will go to arbitration. Or it can be only from my panel. Then only, that was a question that had come from Lordship in the beginning. What if it is a conditional arbitration clause? But the requirement of section 7 is limited to intent to arbitrate. Right to appoint or unilateral right to appoint or limited to panel of appointment has to be divorced from it. They cannot go together. Once the test of intent to arbitrate is satisfied, then law kicks in.
Yeah.
That's my first point, Lord. I put it in my note, submission number 1. And Lord, intent to arbitrate has been recognized in the Cox and King's judgment, which on the group of companies doctrine. So that's my first point. Intent to arbitrate is the first step. As per 7, arbitration agreement has been defined to means an agreement so and so. It is not predicated as to who will have the right to appoint. Thus, existence of an arbitration agreement gets satisfied as soon as the requirement of 7 is met. Now, my second point is there are 3 aspects of constitution of an arbitral tribunal: intent to arbitrate, commencement, and procedure. These are the 3 aspects before a tribunal is in place. Now, 11(2) uses the word parties are free to agree on a procedure. Lord, actually the main mischief is here. How much stretching do we give to the word procedure? Does it mean procedure in case parties fail to agree? Or would Lordship consider procedure to mean even determining who will appoint among the 2 parties? Procedure will only mean, Lord, methodology. The real problem is procedure, my lord. If Lordship gives interpretation to the word procedure in 11(2), the entire problem gets solved. That's the Gordian knot. Because that is where the agreement is referred to, which gets used. That, oh, I have a right to agree on the procedure for appointment of an arbitrator. That means I can decide who will be appointed as an arbitrator. My lord, my submission here would be, keeping in mind the mischief rule, Hayden's rule, purposive interpretation, the word procedure will have to be limited to mean in case parties fail to agree, then what is the procedure? Lord, that is what is the fallback also in 11(5), my lord. Then 11(8), which Mr. Banerjee had referred, my lord, has the words independence. And it also uses the word other considerations. Lord, Lordship had put a question, what is their other? Those other considerations would kick in because it's a very wide term. My lord, on section 18, my lord, I have referred to the judgment of PAM development, which had made section 18 applicable to even post-arbitration. And my lord, on panel, my lord, I have just 2 points to make. What cannot be done directly should not be done indirectly. If Lordship is permitting one party to appoint an arbitrator, then panel will be justified. But if one party can't appoint a sole arbitrator or the presiding arbitrator, then even panel cannot be justified. Lord, if 3 people cannot be appointed by 1 person.
So tomorrow we'll start with the arguments of the Solicitor General.
Lord, one request, Lord, my colleague says the intervention may be formally allowed, Lord.
Yes, we allow it.
I'm grateful.
ये आप लिफाफा कुछ दिखा रहे हैं ना?
सर वो मैंने
अरे आप दिखाइए तो दीजिए लिफाफा मेरे को। ऊपर से वहां से फहराते हुए चले जा रहे हैं। He write a letter directly to me.
but that's
How can he write a letter directly to me?
but that
And how can he give the letter directly to me? कलेक्टर समझता है कि मेरा एडिशनल कलेक्टर जाएगा तो कोर्ट को देगा, कोर्ट नतमस्तक हो जाएगी। कलेक्टर बैठ जाइए सर आप लोग। थैंक यू।
my lord, for that
Now I will talk to your collector only.
for that, my lord, I'm tendering an unconditional apology, my lord.
For what,
has happened,
sir?
my lord? What has happened, my lord, in Naradapuram district, my lord? One huge Mela, namely Nagdwari Mela, is to be scheduled, my lord, in which, my lord, due to heavy rainfall and landslide, my lord, on 24th, my lord, even one government vehicle, Gypsy, has been rolled
क्या
over
दिखाइए?
from that
दिखाइए
area, my lord.
दिखाइए क्या है?
वो एग्जाम्पशन एप्लीकेशन के साथ हुआ कि
अच्छा कलेक्टर साहब के आप वो दूत बन के आए हैं।
उसमें
वाह 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 वेरी गुड। क्या 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 कागज लेके आए आप? दो ना
नहीं सर वो
एडिशनल जी, ये आप लिफाफा कुछ दिखा रहे हैं ना?
सर वो मैंने
अरे आप दिखाइए तो दीजिए लिफाफा मेरे को। ऊपर से वहां से फहराते हुए चले जा रहे हैं। हाउ कैन ही राइट अ लेटर डायरेक्टली टू मी?
but that
How can he write a letter directly to me?
but
And how can he give the letter directly to me?
that's
Call your collector to remain present at 4 p.m. How can he write a letter directly to me?
no Malord, that's why we
Is it not a letter addressed to me?
Malord, what
Is it not a letter addressed to me?
it has been
Whether your additional collector was showing this letter, was bringing this envelope. ऐसे ऐसे करते चले आ रहे थे।
नहीं सर वो
सॉरी सर, सील करो तो लगाओ। इन लोगों को, आप लोगों की देखिए खुला हुआ है। गांगुली जी, आप लोगों ने देख लिया होगा।
सर
सुन लीजिए,
मैंने फोन
सुन लीजिए,
फिर मैंने सुबह जब लेके आया तो मैंने
सुन लीजिए, आप लोगों ने देख भी लिया होगा क्योंकि खुला हुआ है। कलेक्टर ऐसे फाड़ के तो भेजेगा
नहीं
नहीं।
वो देखा मैंने।
आपने कहा होगा कि इसको मत देना,
हाँ मैंने इसलिए
कहा होगा,
इसलिए मैंने
आपने कहा होगा इसको मत देना।
इसलिए मैं 9
अरे
बजे
कहा था कि नहीं कहा था?
मैंने एप्लीकेशन
अरे आपने कहा था कि नहीं कहा था?
कहा था ना
कहा था। उसके बाद भी आपकी कोई अहमियत नहीं है इस एजी ऑफिस की सरकार के अफसरों के निगाहों में।
नहीं वो एप्लीकेशन
मिस्टर गांगुली, ऐसे अफसरों को बचाने की आप प्रयास कर रहे हैं जो आपको कुछ नहीं समझते हैं। आपका कलेक्टर समझता है मेरा एडिशनल कलेक्टर सफिशिएंट है जज से निपटने के लिए। ठीक है, आपके इंस्ट्रक्शन के बावजूद भी पीछे खड़े होकर लेते हुए चले आ रहे हैं ऐसे करते करते।
सर मैं 9 बजे आके इसलिए एग्जाम्पशन अलग से बना
बहुत अच्छा सर। तो किस बात का है कि एजी ऑफिस कानून के हिसाब से ना सिर्फ काम करता है परंतु अधिकारियों को भी कानून के दायरे में रहने की निर्देश देता है। उसके बावजूद भी इनकी स्वेच्छाधारिता आसमान को छू रही है। कलेक्टर समझता है कि मेरा एडिशनल कलेक्टर जाएगा तो कोर्ट को देगा, कोर्ट नतमस्तक हो जाएगी।
नहीं सर ये
अरे भाई साहब,
ये धारणा नहीं है सर।
स्वप्निल जी, आपको एग्रीव्ड होना चाहिए था।
नहीं सर वो तो
आपको एग्रीव्ड होना चाहिए था कि ये अफसर इस तरीके से बिहेव कर रहे हैं कि आपको कुछ नहीं मानते हैं। यू आर मेकिंग पर्सनल सबमिशंस। अब आपने किसी धार्मिक आयोजन की बात की,
बिल्कुल
राइट? देन
सर उसमें सर
सुनिए
आने वाले हैं
और भी 10 लाख लोग आए। इसका क्या मतलब है कि कलेक्टर हमको डायरेक्ट एप्लीकेशन भेजेगा?
नहीं सर वो
मिस्टर गांगुली, अगर
दैट शुड नॉट हैव बीन डन। दैट
गुलाटी साहब का पक्षकार, अभी मैंने तहसीलदार को क्या पूछा था? पक्षकार आया था आपके पास? क्या एडिशनल कलेक्टर को क्या पूछा है? पक्षकार आया था आपकी जबान बंद करने? नहीं सर। आप क्या अपने आप को पक्षकार नहीं मानते हो? Keep him present, otherwise I will issue a warrant of arrest against him. इसको टाइप कीजिए और अपलोड कर दीजिए। नहीं आए हैं? आए या ना?
ना सर एक मिनट बस मुझे। सर एक्चुअली क्या है कि जो नागद्वारा का जो मेला लगता था वो 15 किलोमीटर का ऐसा ट्रैक है इसमें नीचे जाना पड़ता है और ये जो धूपगढ़ से ये 15 किलोमीटर डाउन द बॉटम नीचे जाना है और ऊपर आना है। तो सर मैंने खुद ट्राई किया मोबाइल में कई बार, एडीएम यहाँ थे उन्होंने ट्राई किया, उनके ऑफिस में
चलिए सर,
ये सब
हम आपको उनका रिप्रेजेंटेटिव मान के उनकी एग्जाम्प्ट कर देते हैं। अब आप इसको जस्टिफाई करिए कि हाउ अ कलेक्टर कैन राइट अ लेटर डायरेक्टली टू द कोर्ट। मुझे उनकी शक्ल देखने से ज्यादा इंटरेस्ट नहीं है। इफ ही इज नॉट इंटरेस्टेड टू अवेल द अपॉर्चुनिटी ऑफ हियरिंग, नो डिफिकल्टी। कोई कंटेम्प्ट तो है नहीं कि मैं उनके खिलाफ वारंट इशू कर दूं, है ना? मैंने उनको मौका देने के लिए बुलाया, उनका कहना था कि हम नहीं आ पा रहे हैं, मत आइए।
मैं 2 चीजें
अरे मेरे भाई, मैं
चीजें कहना चाह रहा था।
सुनिए, मैं कोएसिव स्टेप क्यों लूं? मैं कोएसिव स्टेप क्यों लूं उनके खिलाफ? सिर्फ यही कि वो मेरे कहने पे नहीं आए इसलिए? कैसे ले लूं भाई? अब आप उनके रिप्रेजेंटेटिव हैं, आपने कहा उनको एग्जाम कर दो, कर दिया
सर। आप
कर दिया।
मंडे 10:30 लेना सर।
नहीं, अब नहीं चाहिए मुझे वो कलेक्टर। क्यों चाहिए सर? एक तरफ नेचुरल कैलामिटीज हैं, लोग जी रहे हैं, मर रहे हैं, 10 लाख लोगों की भीड़ इकट्ठी होने वाली है और फिर अगर कल को कुछ हो गया तो कहेंगे हाई कोर्ट में गया था साहब, मैं क्या करता, मैं रहता तो मैं तो एक आदमी ना मरने देता। छोड़िए, you are representing the state is the part of the state government.
She's lady Manoj and
Might be lady, hardly matters. General Clauses Act में he can be read as she and she can be read as he, right?
Holding a
No problem, sir. अगर मुझे लगता कि वो she is avoiding the appearance तो फिर हम अलग से देखते हैं। हमने मान लिया आपकी बात कि साहब वो प्रॉब्लम है, बात नहीं हो पा रही है। अब वो हाई कोर्ट के एजी ऑफिस से हम तो वो कोई फर्क नहीं पड़ता है ना। एजी ऑफिस तो एजी ऑफिस ही है, कलेक्टर को कोई फर्क नहीं पड़ता है। अब आप मुझे इतना बताइए, हाउ द कलेक्टर कैन राइट अ लेटर डायरेक्टली टू द जज ऑफ द हाई कोर्ट?
that can't be done, my lord. So हमने वो ऐसा नहीं करना था, उसको हम exemption हम बना
नहीं सर, I am directing the CS to conduct an inquiry whether a collector can write a letter directly to the CS. Explain that.
should go through proper
True.
channel, my lord. It should be
Then
in
how dare he could write a letter directly to me in that case which is pending? उस आदमी की या उस लेडी की अपीयरेंस का ऑर्डर था, and she was trying to win over the court.
she is trying to
Her position was that of a client only, nothing more, nothing less.
definitely, my lord. But she is trying to explain, my lord.
Whatever the,
But
आप लोग सुन लीजिए,
हाँ,
how she can send a letter directly to the court. I have not spoken a single word. I did not speak a single word when you were trying to explain her non-appearance. Whether I interfered at that time, आपका एडिशनल कलेक्टर, उसको लगता था कि मेरी कलेक्टर है, ये तो कुछ भी कर सकती है. He started waving that letter while he was sitting on the bench.
सर वो सुबह देख के मैंने उसको मना किया.
अगर आपका एडिशनल कलेक्टर को नजर में आपकी कोई अहमियत नहीं है, are you ashamed of that?
सर वो
That impression which the AG office
no, my lord,
is having in the eyes of these persons?
they don't know the procedure.
They don't know the procedure. तो मेरे को यह लेटर दिखाएंगे?
नहीं, इसलिए मैंने आइए मूव
I will pass a letter. And I will direct the suspension of these two officers. मजाक में रखे रखा हुआ है. जब डिप्टी एडवोकेट जनरल कलेक्टर की बेहाफ के ऊपर एग्जामिशन के लिए प्लीड कर रहा है, वो पीछे खड़े होकर मुझे कलेक्टर का ऑर्डर दिखा रहा है, लेटर दिखा रहा है.
that should not have been done, my lord.
I will place him under suspension. देखता हूं कि कैसे सीएस उसको रिवोक करता है. आप लोगों के अफसरों की इतनी हिम्मत बढ़ गई है कि आपको कुछ नहीं समझते, और आपका एडिशनल कलेक्टर कहता है कि अगर हाई कोर्ट जज को कलेक्टर ने लेटर लिख दिया है तो हाई कोर्ट जज तो बस हो गया. ऐसे हिम्मत है हाई कोर्ट जज की, देखते हैं.
समझ नहीं पाया था कि वो मतलब एक तरीके
नहीं डिफेंड मत करिए, मिस्टर मत करिए डिफेंड. वो समझ नहीं पाया था. आई एम राइटिंग दिस ऑब्जर्वेशन, दिस इज द सबमिशन ऑफ द डिप्टी एडवोकेट जनरल, कि उसको समझ में नहीं आता है.
नहीं मतलब
ना तो उस आदमी को अपील, ना तो उस सज्जन को अपील डिसाइड करते समय कानून समझ में आता है, ना उस सज्जन को डिप्टी एडवोकेट जनरल के इंस्ट्रक्शन समझ में आते हैं, ना उस सज्जन को हाई कोर्ट का प्रोटोकॉल है ये समझ में आता है, ना उस सज्जन को हाई कोर्ट की प्रोसीडिंग्स के चलते हुए इंटरफेयर करने में डर लगता है. ऐसे आदमी को आप क्या यहाँ पे रखेंगे?
नहीं सर, मैं डिफेंड नहीं कर रहा हूँ, लेकिन
नहीं डिफेंड नहीं करेंगे, आप रखेंगे, ये बताइए मेरे को. आपने कहा, उसने कहा कि ये मुझे रीजंस लिखने थे और मुझे हाई कोर्ट का ऑर्डर समझ में नहीं आया क्योंकि मैं तो अपने आप को तहसीलदार समझ रहा था. इन दोनों के एक्सप्लेनेशन में देख चुका था, सुन चुका था. उसके बाद जब हमने पूछा कि कलेक्टर आए क्या, फिर आपने कहा क्योंकि मैं ये सारी बातें इनके मुंह से इनके कलेक्टर के सामने कहलवाना चाहता था. ठीक है, आपने कलेक्टर कहा कि सर ये प्रॉब्लम चल रही है वहां पे. आई कुड अंडरस्टैंड कि भाई प्रैक्टिकल प्रॉब्लम है, फील्ड के ऊपर प्रॉब्लम आ रही है, कलेक्टर की प्रेजेंस जरूरी है. ये पीछे से लेटर दिखा रहे हैं मेरे को, मजे लीजिए सर. Yes, Mr. Why you should not be put under suspension directly by this court. Please come forward, sir. Why I should not direct for your suspension immediately? नहीं मत क्षमा मांगिए सर, आप लोगों की अकड़ जरूरत से ज्यादा बड़ी हुई है।
पहली बार मैं अपीयर हुआ,
हाँ, पहली बार अपीयर हुए हैं।
मुझे लगा कि हम जो चीज हमको दिया गया था तो हम
हाँ, कलेक्टर ने दिया है ना, हाईकोर्ट जज को तो मैं जाके देख के आऊंगा।
आप थोड़े सर
वॉट एवर इट इज, आपने सुबह इनको दिखा चुके थे, आप सुबह इनको दिखा चुके थे।
हो जाते हैं।
नहीं नहीं नहीं, आई विल डायरेक्ट इट फॉर हिज सस्पेंशन। मैं जरा डिटेल्ड ऑर्डर आएगा, हो सकता है ये कल ऑर्डर आएगा। हाँ, और तहसीलदार के खिलाफ सीएस को इंक्वायरी का ऑर्डर करूंगा मैं।
कोई
नहीं 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 नहीं, थैंक यू सर, थैंक यू। आपको बताना था, आपका ये, मेरा कोई इंटेंशन नहीं था, मैं समझ नहीं पाया था। मैं तो गांगुली साहब को फिर से दिखा रहा था कि साहब आपने गलत मेरे को मना कर दिया।
Some lenient view may be taken.
Lenient?
I'll take up this matter.
Sir,
If your lordships permit, my lord, then I'll
मुझे 4:30 बजे तक बताइए, मुझे 4:30 बजे तक बताइए प्लीज। यू कैन लीव द कोर्ट एंड यूटिलाइज दिस 23 मिनट्स, अदरवाइज आई विल डायरेक्ट फॉर प्लेसिंग यू अंडर सस्पेंशन। क्योंकि इन्होंने जो किया है वो कोर्ट के अंदर किया है, और वो जो सीएस जो है उसके लिए वो कोई कुछ नहीं जाएगा। कोर्ट के अंदर की प्रोसीडिंग्स के लिए आई कैन डायरेक्ट हिम दैट ही शुड बी प्लेस्ड अंडर सस्पेंशन। जो मुझे कलेक्टर के आदेश का डर दिखाने को बैठे हुए थे, और आपके सीएस को आपके सर आपके सीएस को मैं आपके कलेक्टर के खिलाफ भी इंक्वायरी करके और उसमें जो भी आपको इंटरवीनिंग ऑर्डर्स पास करने हैं उसका भी डायरेक्शन देने वाला हूं। राइट, चलो सर, थैंक यू सर। नो मोर केसेस सर।
On 26th, 27th.
The 27th.
Your Lordship, they've received notices for closure on eviction on 26th, 27th, Your Lordship. They're only bothering.
The notice of closure is 27th.
Eviction, Your Lordship. They are small
First
coach
in
out.
the morning on the 27th. Tomorrow is a very heavy day, so 27th it will come up. I've already done.
Very well.
Well, it's your lordship has twice directed a matter in July and 2nd of August didn't come. Now it is showing happily on 27th August. Please don't delete it.
The lordship's permission, may I mention a fresh matter?
Just send an email, everybody. When did you send it?
Yesterday.
So it's probably already listed. Just wait.
Content coming, that's the only.
Wait, it will be listed. Every email is dealt with. Yes.
Let's have your lordship.
The matter that contains notice came to
Fresh matter.
an after notice. My lord, it got deleted. We have circulated mails for not to be deleted, but nevertheless. It's coming up on 20th of September. Would my lords please direct it not to be deleted on that date at least? May I just pass the details of the...
Just make sure that somebody, the email, advocate on record's name you make.
My lords, the email has been sent by advocate on record again, day before yesterday.
What's the name of the...
My lords, it's Amir Arsiwala.
Yes.
Amir Arsiwala.
That's my apology.
Please, my lords, I'm grateful.
My lords, your lordship said some of the chief secretaries of the states which are defaulted on payments of pension and allowances tomorrow.
Yes.
Your lordships will also ask me to give a list of those chief secretary, those states which have actually complied. I've just passed it on. I've
So
just
we
passed
now,
it on.
just 3 copies. Just 1 second.
For the defaulting states, there is also a request to appear online. My lords, number of applications have been filed, so I just thought I'll go online.
No. The chief secretary, the states which have not complied, they have to be present online. They have to be present here. We have said they have to be physically present. Those who have complied, how many has complied between that order and today now?
The others, non-complying, I've mentioned in my list.
Yes. Others have.
The others have complied. The others have complied.
Yeah, I compliance epidemic.
Who?
I appear for West Bengal, my lords. Most of the states
They have not complied.
those who
Tamil Nadu, Madhya Pradesh, Andhra, West Bengal, Chhattisgarh, Delhi, Assam, Nagaland, Meghalaya, Himachal, J&K, Ladakh, Jharkhand, Kerala, Bihar, Goa, Haryana, Odisha.
Those people have not complied.
They have not complied. They have not complied.
Substantial compliance.
They have to comply. No substantial compliance. By tomorrow, make sure that they comply, otherwise ask them to be here. No. They have to be personally present here. Otherwise, we'll issue a non-bailable warrant. There's no going back on that order. They have to have given enough time. They have to comply, pay by this evening. They have to, there's no substantial here. They are 100% compliance. That's why we've given enough time. We have been giving time from 27th of July 22, 19th May 23 for January 2024. Therefore, we have directed personal presence. And ultimately, and what is not being paid, the arrears of salary and allowances to our district judiciary.
Funds have been released, it has reached all the district fee for the people. Have not come. Below the 99.9%. That's my instructions. Whatever the.
We'll call out each state tomorrow, we'll see. And
it's showing for 27.
yes.
I wanted to clarify whether it's coming up tomorrow. It's not there in the list.
No, it will come up on the 27th, right? 27th. 27th. We'll take it up and then we will call out each state separately and see what the compliance is. Let them be present before us. We'll see.
Lords, may I mention,
My lord, may I mention, Lord, on behalf of the AIMS doctor residents, Lord, Nagpur, Lord, on account of their being participating in the agitation and the protest, Lord, now they are being victimized, Lord, on one ground or the other, being marked absent.
If they are not,
Lord, but they were doing the emergency duties, Lord. But because they were participating in the
are they at work? If they are not at work, they'll be marked absent. How can we ask them to do something?
Not allowing in the exams, Lord, in one way or the other, Lord. If a lenient will be taken, Lord, if a lenient will be taken.
If they are on duty, they will not be marked absent. If they are not on duty, the law will have to follow its course. How can we tell the administration to to write something which is not correct?
Not with respect to the exams and all that, Lord, the lenient will be taken, Lord, because of this reason, Lord, they were on protesting or on strike.
That's all right. So ask them to first return to work.
Yes.
Once they return to work, then if nobody is going to take any adverse action against the doctors,
that
all come back to work.
Word from your lordship will work, Lord, for them.
Let them first come back to work, and then if there's any difficulty, just talk to us in the court here. We'll make sure that there is no adverse action against the doctors.
Very well.
We quite see that they were all upset about the fact that there was a very serious incident which took place, but let them first report to work, and then once having reported,
they have reported back, Lord. They have reported back. They have reported back. AIMS Nagpur reported back. Lord. The resident doctor, they have joined this issue.
Not just mention on behalf of PGI Chandigarh. Your Lordship, there is Lordship in PGI Chandigarh. They are going in for a rally for 2 hours in the morning, but they are doing all their duties. But for 9 days, their CL has been deducted now from the leave. So that is a victimization. You also have to write the research papers and.
I don't think somebody like Dr. Vivek Lal, he's the director at PGI Chandigarh, that he will do anything which amounts to victimization.
Lordship, I'm only saying
that ultimately the directors of these institutions,
he made a statement.
They also have their heart with the doctors, but they are in a situation where poor people who come to those institutions cannot be left behind in the lurch.
Yes, sir.
That they take appointments 2 years before the actual date, and then suddenly you're told that you will not be attended to. Let them all resume work. And I'm sure the directors are all very seasoned directors who spend their life in these institutions. They're not going to do anything against the doctor.
I think
right now the notice that they have been given is that since or for 9 days you've been on the rally, so we are deducting your 9 days of casual leave.
We'll pass some general order.
Yes.
Pass some general order on that.
Lordship, may I make one?
May I say something?
Please rest assured that once the doctors, we hope, resume duty, then we will prevail upon the authorities not to take any adverse action.
Yes.
But they must first come back to duty for the simple reason, otherwise the people who,
They are on duty. They are, all of them are on
people who need the services the most are deprived of their services. That's the only concern. How does the public health infrastructure run if the doctors don't resume work?
Lord, only my lord.
All right, now first let's have the status report. We first want to see
Lord,
the
these are
status
the three
report.
copies. Lord, I believe the anguish of the doctor is correct, but having come from your lordships, an assurance that your lordships are looking into it, my lord, I think that should satisfy.
Malaja.
with the assurance of no adverse action, my lords.
Lords, we are absolutely not grateful to your lordships that lordships have intervened. Lords, we have not been heard, my lords, at all. Our grievances, my lord, are at the forefront because we are, my lord, facing the brunt of this, my lord, whatever
Well,
is.
the reason why we constituted such a broad-based committee is we have specifically said that the committee shall engage with all stakeholders, including, that will include the resident doctors. So please assure them, that the committee, one second, Mr. Ansaria. Please assure the resident doctors, they all are young doctors, that they will be heard by the.
We heard, my lord, and some representation.
But tell us one thing, we can hear you, Mr. Kamath. We hear you for half an hour. We are not the committee. Ultimately, you have to be heard by the committee.
Yes, what we were requesting, my lord, some, my lord's association, whatever your lordship choose, Lord, some representative from the resident doctors association, if they can be a part of the committee.
Yes.
But their
One second, Mr. Ansaria.
I'm sorry, I'm not saying.
You see, please understand.
we leave it to your lordships, my lord.
Mr. Kamath, please understand. We have thought through this very carefully. If we start now asking for the representatives of various stakeholders to be a part of the committee, that becomes an impossible process because, the committee's work will then get dislocated. You know what happens. You have such an experience yourself. At the same time, we are conscious of the fact that the primary concerns of the doctors, the nurses, the paramedical staff, that has to be taken into account by the members of the committee. For two things that on the committee, we have very senior women doctors in the committee. The doctors who are on the committee are people who have worked for a long time in their life as part of public health infrastructure. So therefore, what we have expected the committee to do is that the committee will hear these various stakeholders, namely the interns, the residents, the senior residents, representatives of the nurses, the other paramedical staff. So therefore, they are in a hospital, there are a huge number of stakeholders. The committee will ensure that it will hear representative.
Hold on, Lord. In fact, I have taken instructions. I represent about 30,000 doctors.
Please, and Mr. Kamath, please tell them that the committee will definitely give them a hearing. We'll reiterate that in our order today. We will certainly, Mr. Kamath, your point is well taken. We'll make it clear.
My lords.
Absolutely, Mr. Kamath. We are grateful to you actually for personally because our hearts go out to all those people who have to go to public hospitals. So we will make an observation that the committee would hear all stakeholders, including the Resident Doctors Association. Of course, not 30,000 doctors, but a representative.
One pardon application.
Right. And an appointment can be given to them when the committee assembles, so that the committee can, because your stake is very high and your inputs are very valuable. So please assure the resident doctors that we were now passing an order that the committee will give them a representative voice in putting forth their grievances, their working conditions, so on and so forth.
Suggestions. Today and
Our suggestion.
can then call off their Milord's protest. Milord.
We will also say that.
I appear for the RG car.
Can I?
Mr. Ansari and then Mr.
Yes.
Lord, I appear for the Delhi Medical Association.
Yes.
Lord, we filed a writ petition in 2022, Lord, raising the same grievance.
Right.
This court says, as and when any incident happened, Lord, we are grateful to your Lordship. Lordship could show moto, otherwise we were contemplating to file. There is a judicial order there, any order, Lord, any incident happened, then you come to us, Lord. Lord, now, Lord, we are the association of 110 years old. As Mr. Kamath has said, Lord, there is a being a part of the committee. I'm so sorry.
Can we just suggest one thing?
Yes, my lord.
Because, in such a large matter, we have to.
तुम नारी हो, लचीली कमर, कोमल कलाई, नाजुक कंधे।
हम क्या है दुनिया को दिखाएं, अपने अंदर की ताकत जगाएं। ऑप्टिमम न्यूट्रिशन के साथ जीत को हासिल कर जाएं। ऑप्टिमम न्यूट्रिशन, अपने अंदर की ताकत जगाओ।
Just suggest one thing.
Yes, my lord.
Because in such a large matter,
Yes.
we have to bring some order to the
My lord.
order to the order also, which we pass.
Please, Lord, sir.
If all of you who are intervening for various bodies
Yes.
can give on a slip of paper
Yes.
name of the body
Yes.
and whom you represent,
Very well.
we will put that in our order.
I understand.
So that your clients have that assurance that look, the Supreme Court is also factored in our
I understand, my lord. That will be very useful.
So then we will say that out of these, the committee may take an appropriate decision on engaging with the representative.
All that we were saying, my lord, the committee constitute of a very respectable persons, my lord. Lordship has chosen them. But some representation from the associations, my lord, those who face day-to-day, my lord, problems. Making representation to the committee and being a part of the committee, my lord, would be a little, my lord, we have been hesitating this law. I'm sure, but Lordship thinks it appropriate. Lordship might take it, my lord.
I'll get a response from.
And
That would be very helpful.
I had made two more aspects, my lord. Two more small aspects. Lordship has flagged, my lord, about 11 issues which the committee will take into account. Two more aspects, if your lordships can kindly consider that. One is, my lord, the distress call, my lord, we mentioned it day before yesterday. Lordship said it will be part of the order, my lord. I have seen, my lord, it is distress call system, my lord, which is available, my lord, on drop on a watch, on a mobile, my lord. That can also be, my lord, a part of it. Secondly, my lord, institutional FIR, my lord. What has been happening here is, my lord, the parents has to go, the relatives has to go. There should be an institutional FIR within 2 hours of a cognizable offence, my lord. If that also comes with your lordship, part of the order, my lord. And finally, my lord, the fast tracking of, my lord, we have done cases 10 years back, my lord. The trial is still proceeding. My lord, in 2016, my lord, a person was murdered, a doctor was murdered inside the hospital, my lord, at a point blank range, my lord. Nothing happened. There was a widespread agitation. The chief minister said 50. What I'm saying, there are similar matters pending in this court. If a lordship expedite that.
To obviate, handing over slips, but we'll go about in a very systematic way.
Yes,
Mr. Devdatta Kamath is appearing for whom?
Instead of your lordships writing down, let us give it.
Can we just, it will be easier for us.
It would be easier. It doesn't look good also.
All right.
My lord, very kind, my lord, but
All right, what we are doing is, we are just circulating a sheet of paper. If you can all just, as we are going along with the matter, write it. So we'll examine that and we'll put your names down.
I had made a request
My lord,
Some SOP, the committee is looking into it. There is no SOP on the hours of the doctor.
Of course, we said that.
it is a specific
it's a mandate.
remit of the committee.
One second. One of the points which, that one para where I say, this is a non-exhaustive list. It specifically says that they are made to work for 36 hours. And one more thing, we have said, we have referred to working conditions in general, which includes the work. So please assure the doctors, we are as concerned about them, that they have to work for 36 hours.
Yes.
All of us have also had family members, relatives. We have gone to public hospitals.
Yes.
I have slept on the floor of a public hospital when somebody in the family was not well. So we have gone through that. And you observe all of them working for 36 hours.
Lord, we would
Lord,
also not like, we would not like, my lord, a doctor who has not slept for 30 hours to treat us, my lord, because
May I just explain what happens in the hospitals? Because I have doctors in the family and also people studying in the medical colleges. What happens is that the senior, who are the third-year students of PG courses, they are the one who assign duty. You do 12 hours to 24 hours, and then thereafter you are given a rest for 2 to 3 hours. Again, you are called back on duty. The junior doctors are the one who prepare the discharge summary. And the discharge summary is prepared by them. So the workload is then again 2-3 hours. So it is almost 48 hours. It is not even 36 hours. So my humble submission is that you are neither in a physical state or a mental state at that stage to even resist if somebody is teasing you. I'm not even on the bigger sexual assault. I'm not on that because there are many incidents.
Currently, if you look at our order,
yes.
Ms. Kumudal Das, if you see our order,
Yes, Your Lordship.
If you see our order, we have in fact highlighted this very aspect, that there is a certain hierarchical nature of the workplace in a public hospital or any hospital. So when we have referred to that, and we have said because of the hierarchical nature, doctors, including junior doctors, are susceptible to harassment, not just sexual harassment, but different kinds of harassment.
Yes, Your Lordship. Yeah.
So we have specifically referred to this, but now that you have mentioned it, in a course of our order, in a brief order today, we will add to that as well. No difficulty. Your point is perfectly well taken. So please.
My Lord,
that
a
is-
small point to supplement that.
say,
Is that
Yeah.
because
My
I
Lord,
also
may I
come
just
from a
take a
family of
minute?
doctors, is that the counter to that, of course, is the fact that there are lots of peer-reviewed studies to say that continuity is important. Now, obviously, doctors can't be treated like this in light of that. So the committee should look into it and propose something
You see,
that
there is
has
another, I'll
adequate
tell you one thing.
safeguards.
I'll tell you one thing. We have got so many emails. I've been flooded with emails which I've been reading to the extent humanly possible. There's another viewpoint also that, look, if you have doctors only on duty for 8 hours, then the purpose is that the doctor must be able to see the evolution of the patient. So that patient is there overnight, then your duty hours may extend beyond 8 hours so that you see that what is the development in the case of the patient between the time you entered and the time you exited. But we are not going to make any comment on that. The committee will.
Your Lordship,
but for
Your
all
Lordship,
one other
Certainly,
One thing is
48 hours of duty or 36 hours of duty is a little too aggressive.
is not really human. My Lord, may I say I'm representing the KG Car Medical Junior Resident Doctors. They are still RG Car. And my Lord, they are
By
still.
the way, Brother Justice Rishikesh Roy pointed out to me in another CB yesterday that you kept on saying car is car. So I said, well, I
We are
apologize.
forgetting one crucial thing.
So, my Lord,
Can I speak?
can I
We are
just?
forgetting one crucial thing. All doctors, my lord, which your lordships have constituted in the committee, they have passed through this very phase. They are aware of the problems.
So, my Lord, I'm just saying that they are still terrorized. They are still in fear. They are saying our senior residents are back at work. We'll give it to the Registrar General in a sealed cover, the names of the people. There are about 70 junior residents and they are interns. And they are still feeling terrorized. They are threatened. They are actually being targeted in the hospital.
But terrorized by whom? Because this is a serious thing. And the
Yes.
in the RG Kaur Medical Hospital. Medical College, what is their
But
grievance?
instead of, my lord, giving them here, let them be given to me. I'll ensure, my lord, CISF to do the needful. My lord.
Yes, but we have to have their names in sealed cover because those who've spoken up are feeling targeted already. And they have a timeline of videos they have taken.
Targeted by whom? Don't give us names, but targeted broadly
By
by
officials, my lords, by goons, I am for
By-
20,000 doctors in the, Kolkata, my lords.
But
And
your lordship sees the
many of them work in RG Kar.
possibly a hint of.
By members of the administration, by people who are in the hospital.
All right,
and
we'll take note of that.
Yes,
There's one submission, Your Lordship. There's a last submission, Your Lordship, I want to make. Can we have a compensation distress fund for the victims and the deceased of the family created by the state so that when at the time of the crisis of this kind of situation, they can be also get a compensation system like what we have done in the Nirbhaya case, Your Lordship.
All right, let's just see the status report for a moment. We'll just see the status.
With your lordship,
Just give us one moment.
with your lordship permission, may I just
1 second. We'll have to
Lordship
put in.
permits us, then should we post on the e-filing, the suggestions or the pointers that we have, because it is anonymity which the resident doctors and interns from different places they are requesting, because the direct impact is on them. And their mental state is terrible. There is also a survey report of National Medical Council which says that 28%.
Point taken. There should be a portal where suggestions can be given to the committee, even anonymously, without disclosure of identity.
Yes, Your Lord.
Point well taken. Noted.
Lords, after the status report, could we have 1 minute on the SIT, my lords? We are representing 5 associations of doctors. And the difficulty is that there is an institutional compromise with regard to the financial regularities and the rape. Here's why. There were the same gentleman who was the head of Dr. Shundip Ghosh, who was head of this RG Kaur Medical College, also, for example, commissioned, asked for CCTV cameras for 14 lakhs to be rented. Now, had he bought those CCTV cameras, they would have been there. It would have been a deterrent, and there would have been better accountability. An SIT 2 days ago was, and I have the notification here, my lords. An SIT was set up by the West Bengal government. To look into these irregularities by the same person, and that only constitutes officials that are under the control of the West Bengal government.
But would your lordship consider having the status report?
ಈ ಬಟರ್ ನೊಂದಿಗೆ ಇನ್ನಷ್ಟು ಟೇಸ್ಟಿ ಆಗಿದೆ. ಯಾಕೆಂದ್ರೆ ಟೇಸ್ಟ್ ನೊಂದಿಗೆ ಇದು ಇಮ್ಯುನಿಟಿ ಕೂಡ ಉಳಿಸಿಕೊಳ್ಳುತ್ತೆ. ಹೊಸ ನ್ಯೂಟ್ರಿಲೈಟ್ ದೂದ್ ಶಕ್ತಿ ಪ್ರೋಬಯೋಟಿಕ್ ಬಟರ್ ಸ್ಪ್ರೆಡ್. ಇದು ಇಮ್ಯುನಿಟಿಗೆ ಸಪೋರ್ಟ್ ಮಾಡುತ್ತೆ ಮತ್ತು ತುಂಬಾ ಟೇಸ್ಟಿ ಆಗಿದೆ. ನ್ಯೂಟ್ರಿಲೈಟ್ ದೂದ್ ಶಕ್ತಿ ಪ್ರೋಬಯೋಟಿಕ್ ಬಟರ್ ಸ್ಪ್ರೆಡ್.
ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಜ್ಯುವೆಲರ್ ಆಗಿ ಮಲಬಾರ್ನಲ್ಲಿ ನಮಗೆ ಪ್ರತಿ ಶುಭ ದಿನವೂ ಅಮೂಲ್ಯ. ಈ ಕ್ಷಣದ ನೆನಪನ್ನು ಸ್ಮರಣೀಯವಾಗಿಸಲು ಮತ್ತು ನಮ್ಮ ಸಂಸ್ಕೃತಿಯ ಭಾಗವಾಗಲು ನಾವು ಚಿನ್ನ ಆಭರಣಗಳನ್ನು ತಯಾರಿಸುತ್ತೇವೆ. ನಮ್ಮ ಸುವರ್ಣ ಸಂಸ್ಕೃತಿ, ನಮ್ಮ ಮಲಬಾರ್.
Earlier form
is so powerful that
is the earlier form.
That my lords, he's been refined.
All this.
He's been refined. Please.
In the nurse's case,
Please,
he was the IG.
Your lordships, my lord, consider the report first, my lord.
All right.
That might, my lord.
My lord, with regard to the SIT, just to close that loop.
Let's see the report and then we will come back to you on the SIT.
Yes,
We've also filed our report.
Your Honor, I'm Dr. Rajiv Yusuf calling from
Just 1 second. Everybody can just hold their patience for 2 minutes. Let's quickly run through the two status reports.
The state's report was not called for, but they have, my lord, asked. Your lordship's may, my lord, it's entirely your lordship.
Called for in the order. Why did my learned friend say that?
Order.
I thought we had asked for the
Yes, of course.
The order.
Page 10, my lord. Raise, please, my lord.
In
page
fact,
10 of yours.
in fact,
Mine.
I might, if your lordship will give me a minute, Madhaj, I don't want to interfere.
We'll just quickly run through this, then come back to you in a moment so that we go step by
Very
step.
well.
10, para 7. Lord, before that, we have narrated the facts, etc., which broadly your lordships are aware. So I'm not, and I'm obviously not reading, my lord. Your lordships may read from para 7. So date and time may kindly be, my lord, taken note of. My lord, eventually we have, this is very, very preliminary finding, but we have recorded some, flagged some issues.
We'll just
I'm just ask if they have a spare copy. Please read.
Everyone.
It's only for the court.